The Honorable, the Senior Associate Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
Will the Clerk of Court call the case?
Called for today's oral arguments is the case in GR number 180016, Lito Corpuz versus People of the Philippines. Appearing as Amicus Curiae are the following: Dean Jose Manuel I. Jocno and Professor Alfredo F. Tajar. For the Office of the Senate Legal Counsel, Attorney Maria Valentina S. Cruz. As counsel for Petitioner, Attorney Mario L. Bautista. As counsel for Respondents, Senior State Solicitor Florin T. Hilbay, Assistant Solicitor General Rex Bernardo L. Pascual, Senior State Solicitor Arturo C. Medina, State Solicitor Jose Carlo H. Niebres, State Solicitor Maria Rita Cecilia de Leon Abad, Associate Solicitor Joel N. Villaceren, Attorney 2 Christian P. Castro, Attorney 2 Jeros S. Dolino, Attorney 2 Jovi M. Valenton, Attorney 2 Soliel Flores, Attorney 2 Samira Ninfa Tansinco, Associate Solicitor Emerson S. Bañez, and Associate Solicitor Maxima Paulino T. Season III. As agreed, Petitioner and Respondent will each be given 30 minutes to argue, followed immediately by a period of interpolation after each presentation. The Amicus Curiae, Dean Jose Manuel I. Jocno of the La Salle University College of Law, Senate Legal Counsel Maria Valentina Santana Cruz, and UP Professor Alfredo F. Tajar will have 10 minutes each to express their views. The Court may, if it wants, ask them questions regarding those views.
You may sit down. You may take the podium.
Good afternoon, Honorable Justices of the Supreme Court.
Excuse me, can
Yes.
you change this microphone work better than that one? Start this time again. Huh? Please reset it.
Good afternoon, Your Honors. If it please the Court, let me begin by saying that in resolving the issues at hand, this Honorable Court need not declare any law unconstitutional. Much less is the Court called upon to engage in judicial legislation, which we all know is abhorrent to the constitutional principle of separation of powers. All this Honorable Court has to do in deciding on this case is to perform one of its basic judicial functions, which is to interpret and apply the law giving primary consideration to legislative intent. The main question before us is this: can this honorable court, quote-unquote, modify, although I prefer to use the word harmonize, the penalties imposed in property crimes by adjusting the peso value of the article subject of the crime to its equivalent peso value in 1939. The Office of the House Speaker, the Office of the Senate President, and the Office of the Solicitor General, collectively representing what I may refer to as the opposite view, say that this honorable court cannot. They say that if the court does so, it will amount to judicial legislation. May I briefly read what they submitted to this court? Congress, quote, "The law is clear where a concerned statute is free of any ambiguity. The judiciary's only duty is to apply the statute precisely as it is written. It cannot exercise discretion to modify penalties by the application of inflation as raised in this case. To do so would amount to judicial." The General says, "Interpretation by the courts is not necessary where the law is clear and categorical. The only duty of the court is to apply the law. Said provision is clear and categorical and does not require further construction from the court. To modify the penalty by backing the amount of the thing subject of estafa to its price in 1932 would result to a judicial interpretation akin to legislation." The Senate, on its part, echoes the same grounds. When the law is clear and unequivocal, as in the present case of that portion of Article 315 of the Revised Penal Code, it should be applied. The Honorable Court should not take liberties with the mandate of the law by modifying the same by considering the present value of the thing subject of the offense, adjusted to 1932 prices, lest it be accused of engaging in judicial legislation. With due respect, we humbly disagree with this opposite view. We submit that perhaps in 1930, the meaning and the legislative intent behind the penal provisions on property crimes may have been clear, unambiguous, and free of doubt. But no longer are they so today. 84 years later, when the equivalent of 1 peso in 1930 is that of 100 pesos now. It is apparent that the opposite view have examined the penalty provisions on property crimes through a myopic, microscopic lens. They merely looked at the words of the pertinent provisions in isolation from the rest of the code. They derive their plain literal meaning and right away declare that they are clear, unequivocal, and free of doubt. But this overly simplistic, limited, and cavalier approach to ascertain the meaning and legislative intent of penal provisions on property crimes runs counter to a settled rule in statutory construction. And I quote, "It is a basic rule of statutory construction that the provisions of the law must not be read in isolation, but as a whole. The law must not be read in truncated parts. Its provisions in relation to the whole law and every part thereof must be considered in fixing the meaning of any of its parts in order to produce a harmonious whole." Appeals, Cocofed versus Comelec. And so, Your Honors, in ascertaining the meaning and the legislative intent behind the penal provisions for penalty crimes, we need to scrutinize and consider the revised penal code in its entirety. It is fatal error to examine the provisions in isolation, as was done by the opposite view. The revised penal code is based on the Spanish Código Penal of 1870. It follows the classical school of criminal law. Under the classical school, retributive penalties are standardized or fixed. They are mechanical and generalized. There is hardly any for and aggravating circumstances are taken into account in the imposition of penalties. As a rule, a corresponding felony and its accompanying circumstances is meted out a fixed, specific, corresponding penalty. This rule is strictly followed throughout the code because the code is governed by the underlying philosophy of proportional retribution. May I stress that? The code has an underlying philosophy of proportional retribution. That means that graver offenses, as determined by Congress, are punished with more severe penalties. This philosophy of proportional retribution is woven into the provisions of the revised penal code and is an integral part of it. By way of example, proportional retribution is reflected in Book 1, Article 9 of the revised penal code, which categorizes offenses as grave, less grave, and light. And graver offenses are penalized more severely than light offenses. In Book 2 of the Code, felonies are presented in the order of their gravity. Title 1 first addresses crimes against national security and the law of nations, which are the most grave offenses, while the final title deals with reckless imprudence, considered merely as a quasi-offense, considering that it does not involve dolo or criminal intent. In between the first and last titles are crimes punished in logical and proportional calibration, again, according to their gravity. When the revised penal code was enacted in 1930, the penalties for property crimes were faithful to this philosophy of proportional retribution. The greater the amount or value of the article stolen or embezzled, the more severe the penalty. And also, these property crimes were punished less severely than the graver crimes of treason, rebellion, murder, homicide, but more severely by the lesser offenses of, say, reckless imprudence. But today, by reason of time and inflation, this hierarchy of penalties has been destroyed. The penalties for non-property crimes have remained the same, while those for property crimes have become flexible and excessive due to inflation. In order to preserve and implement the true and original intent of the Congress in 1930, this honorable court should harmonize the peso values of today to their equivalent values in 1930, consistent with the code's underlying. Another rule in statutory construction is that, I quote, a literal application of any part of a statute is to be rejected if it will operate unjustly, lead to absurd results, or contradict the evident meaning of the statute taken as a whole. The courts have recognized with almost pedantic adherence that what is inconvenient or contrary to reason is not allowed by law. Solid Homes versus Spouses Ancheta, July 29, 2005. We submit that if we adhere with the opposite view, the law will, quote unquote, operate unjustly, lead to absurd results, or contradict the evident meaning of the statute taken as a whole. The 1930 Revised Penal Code sets down a scale of penalties for fraud based on amounts as follows. If you embezzle 1 centavo to 200 pesos, you will be imprisoned for 2 months and 1 day to 6 months. May I repeat that? 1 centavo to 200 pesos, 2 months and 1 day to 6 months. 201 pesos to 6,000, 4 months and 1 day to 2 years and 4 months. 6,000 to 12,000 pesos, 6 months to 4 years and 2 months. 12,000 to 22,000, 4 years to 8 years. 22,000 and above, 6 years, 8 months, and 24 days, plus 1 year for every additional 10,000, but not more than 20 years. So if one today embezzles an amount of 142,000, he will be imprisoned for 20 years. This 142,000 is equivalent to 1,420 pesos in 1930 and will be punished with imprisonment of only 2 years. Surely, these peso amounts and the corresponding penalties, if not harmonized, are absurd, and worse, they are unjust. The situation is more shockingly abundantly clear with regard to qualified theft, which raises the penalty 2 degrees higher than that imposed on simple theft. So if a maid commits qualified theft, these are the penalties. An article worth 5 pesos, she gets a maximum of 6 years in prison. Worth 39 pesos, a maximum of 12 years in prison. 150, 14 years and 8 months. An article worth 5,999, 12 years maximum in prison. 19,000, 20 years. Or if an article is worth 125,000, she gets a maximum of 30 years in prison. So if ignorant
interpolation. So we will ask the counsel for the respondent, the ASG Rex Pascual.
Thank you, Your Honors.
Okay, I'm sorry. Attorney Bautista, will you please return to the podium? The other justices will ask first. Anyone? Yes, Justice Peralta will start the interpellation.
Good afternoon, Justice Peralta.
Good afternoon, Attorney Bautista. Now, when I was listening to your arguments, do you think that your arguments should have been made to Congress and to the Senate, not before the Supreme Court?
I think the Supreme Court should also be advised of these arguments, considering that the remedy is well within its judicial function of interpretative power.
Okay, so at any rate, in your first statement, you do not come here to declare provisions of the incremental penalty or the penalties in crimes against property to declare the same as unconstitutional, but you are coming here to pray to this court that we harmonize the provisions on crimes against property. Did I get you correctly?
That's correct, Your Honor.
How will we harmonize? Will you please just teach us how we will be able to harmonize?
The harmony can be achieved by adjusting the peso values of the crimes subject to today's prices to the prices of 1930.
And what would be the money value that we are going to apply in order to harmonize the penalties under these particular crimes?
The money value, Your Honor, I submit, can be determined by experts of economy, business, and finance.
Is it not that in determining the penalty, the money value is only one of the factors in determining if the penalty is proper or appropriate?
For property crimes, Your Honor, I think the more primordial consideration is the amount, considering the excessive inflation increase.
The amount is merely provided to determine the proper penalty imposed.
That's
but
correct.
the penalty that is provided for by law is the penalty for the unlawful taking. The unlawful taking is the one that is punished. But
Yes.
there must be a value as far as the subject matter of the unlawful taking is concerned, in order that there will be a higher penalty to those properties that have higher value.
That is correct, Your Honor.
So, if we now determine what is the proper penalty to be imposed, the money value is not only the one that we have to consider. We have to consider the effect on the private offended party,
Yes.
the effect on the offender, the effect on society.
Yes. But that is
So,
true, Your Honor.
Is the Supreme Court then equipped?
Your Honor.
Is the Supreme Court then equipped with all these resources to determine all these factors and then say that these are the factors and therefore we will impose this penalty in order to harmonize the penalties insofar as crimes against property are concerned? What I'm saying is this. No. The money value is not only the factor that determines the penalty. It may include the effect to society, the effect on the offender, the harm to the private offended party.
May
Is
I
it not?
speak here?
Yes, go ahead.
If we pursue that logic further, Your Honor, the question is, how about the other offenses?
That's why.
How come the other offenses, the penalties have remained the same since 1930 to today?
Yeah, but what I'm saying
But
is
the
that
effects on society, the effects of the crime itself may have changed. But the penalty remains the same,
Yeah,
which is
that's-
not the same in the
that's why I
case
asked,
of property
that's
crimes.
why I asked you this question. The premise of my question is, how do we harmonize? Is it sufficient just to determine the value and then say that because the values were fixed in 1932, the values have already changed, so this must now be the penalty?
Your Honor,
That's what I get from you.
yes, I am just a humble lawyer, but I have great faith in the Supreme Court. I have great faith in the Supreme Court.
Oh, thank you for that.
Yes,
Thank you for that.
I wouldn't be here if I didn't have faith in the Supreme
I
Court.
know. Yeah, I know. I know you. You're a friend, no?
Thank you, Your Honor.
You're a
And
friend.
I am confident that with its resources, the Supreme Court can find a way of how to quote-unquote harmonize
Yeah.
the amounts of today to those in 19.
My other problem is how to go about it. No? You're aware that there are several provisions in the revised penal code where the penalty is dependent on the value of the
Yes.
subject matter of the crime.
That's right.
Yeah, you're aware of that.
Yes.
In fact, there are numerous.
Yes.
Now, if we will harmonize the penalties, take into account your suggestion that because the value has already increased, what will happen with the other crimes? You know, what is in issue here is the penalty in 309 or 315. For
315, Your Honor.
Yeah,
is
315, actually 315 is the same as the penalty in 309. That's why you were using qualified theft as an example.
Yes.
To show to us that qualified theft is so severe because the penalty of qualified theft is 2 degrees higher than the penalty of simple theft under
theft.
Article 309.
That's correct, Your
That's
Honor.
why I'm also using theft because the incremental penalties in theft and STAPA are almost the same. In fact, they are the same actually. The amounts quoted there are the same. So my problem is this. I think I got you right when you said that there must be a comprehensive study of the revised penal code.
Yes, Your Honor.
Yes. Because if we touch on the penalty of 315, then you might as well touch the penalty of 309.
Yes.
And we will now touch on the penalty of 310.
Yes.
And so on. There are so many crimes affected by the value, by that value fixed in 1932. I'll give you an example. The illegal logging law under Section 68 of Republic Act of PD 705 as amended. The penalty on that illegal logging law is dependent on the amounts mentioned in Article 309 and 310 of the revised penal code. The value of the log, subject matter of illegal logging, is based on the value provided for in Article 309, which is simple theft, and under 310, which is qualified theft under the revised penal code. If we will change the penalty, the incremental penalties in 309 and 315, what will we do now with the penalties under illegal logging, where the penalties there are those that are provided for in Article 309 or 310 of the revised penal code?
If I may, Your Honor, please.
Yes, go ahead, please.
I think there's no disagreement that there is a need to do something.
I agree with you. I agree with you.
Yes.
That something must be done to it.
Yes.
My only problem is this, no? Is the Supreme Court equipped
Yes.
with all the resources?
Yes.
In-
As
in
between
other-
the Supreme
in other
Court
words-
and the Congress, Your Honor,
Yeah, in
I
other
would
words-
much prefer that the Supreme
in
Court
other words-
tackle the job.
In other words, on our own, now we are changing 315 because it will also affect the penalties under illegal logging. It is time also for the court to change the penalties provided for in illegal logging because the penalty is in illegal logging is the same as the penalty of 309 or 310 of the revised penal code. Can we do that?
All these questions will have to be addressed by
Before.
Congress anyway.
That's
So why should not the Supreme Court do it now?
Why not file a petition for mandamus? So that we can, you can ask Congress, the Congress will be compelled to perform a duty required by law.
Congress.
Yeah.
84 years have passed, Your Honor. And as I pointed out, there isn't even any work on Book 2. How many years will the inmates still wait?
Yeah,
And all
because-
these questions you ask, which are very valid questions, will have to be addressed by Congress anyway.
Yeah,
and
yeah.
who are better equipped
Yeah.
to do it than justices of the Supreme Court and the bar?
I get your point, no? Probably, there are really some provisions that should be reviewed, no?
Yes, Your
But
Honor.
my problem is, can the Supreme Court do it
Yes, I submit it can do it.
without violating the principle of separation of power?
Your Honors, please. I quoted the main arguments of the House, the Solicitor General, and the Senate, precisely because I wanted to underline that in their own minds, they framed the issue as one of statutory construction. In their very own comments, the first and primary defense they say is the law is clear. Therefore, apply the law. Who determines if the law is clear or not? It's the Supreme Court. Who interprets an unclear law? It is the Supreme Court.
Yeah,
They themselves framed the issue under a statutory construction problem. I was not the one who did that. They did. And I think it is really a statutory construction problem, which is well within the prerogative of this court.
why not give a chance to Congress
Your Honor,
to resolve the problem?
I've been thinking out of the box
Yeah,
on
because you
this.
were saying that they are busy with Cha-Cha. and
Among other things, Your Honor.
and preoccupied. Do you know that the Supreme Court is so busy with RH Bill, DAP cases? We have just finished cybercrime law. We are expecting a motion for reconsideration. We have also many things to do. We are doing many things in the Supreme Court also.
That's why I pleaded in the end that in your heart of hearts, you will know what to do.
Yeah, we won't like to. Okay, I'll go to another point. Yeah. Anyway, you were giving an example about that maid in qualified theft. That stealing by domestic helper is a qualified theft. I think that's not correct.
I beg your pardon?
Stealing or the unlawful taking of a domestic helper from the employer is not qualified theft.
Per se, it is not, but if she
It's
had
not.
possession,
It is the
yes.
grave
Yes,
abuse of
yes.
confidence.
Yes.
No?
I
So it's
used
not
the
merely
example.
it's not merely taking the property of the employer that makes
Absolutely
it a qualified.
correct.
Yeah, that's correct.
Absolutely
so we agree on
correct.
that. Okay.
There must be the element of confidence.
Do you consider the penalty unconstitutional, the incremental penalty unconstitutional, or degrading, or inhuman, and therefore violation of Article 19? I think
I've cited the case of U.S. versus
Section
Wales,
19 rather.
which is a Philippine case decided by the United States Supreme Court when the Philippines was still under the Americans.
Yeah. Now, I ask you this question because there have been so many cases already decided by the Supreme Court that when you speak of cruel or harsh punishment, it's just the nature or the character of the penalty that will be detested if it is cruel or inhuman, like probably cutting of the hands in the crime of
Yes.
stealing. That is inhuman, that's degrading, that's cruel. Or probably cutting the private organ of a male in the crime of rape. That's inhuman.
If Your Honor,
But
please.
imprisonment, as the Supreme Court has said many times, starting with the case of People versus Estuesta,
Yes.
People versus De La Cruz,
Yes.
the latest case of Lim versus People in 2002.
Correct.
It's not, insofar as fine or imprisonment is concerned, it's not this, the severity does not necessarily mean that it is harsh.
Yes, Your Honor.
Yeah.
But
What is
there are
prohibited-
abundant jurisprudence abroad that consider excessive imprisonment terms
I think extreme.
as constituting. In this circumstances, I would think so.
Yeah, it's
The-
not
the-
excessive, it is extreme.
I would think so, Your Honor.
Extremely excessive.
In my humble opinion, it is extreme.
Yeah, okay.
Can you just imagine spending a day in one of our jails? Your Honor, we practiced once upon a time as young lawyers, and we used to visit our clients in jail, and we know how subhuman the conditions there are.
Yeah, because what would be your suggestion as to the money value that should be that should be given now to Article 309 or 315? The money value should be the ratio. I mean, it should be 1 to 100 or 1 to 1,000 or what?
From the statistics I've seen, and I have not studied this in depth, Your Honor, I think 100 to 1 would be a conservative
100 to 1. So the 100 will become
1 peso.
no. The 1 peso will become 100.
Yes.
The 12,000 will become
120?
120,000.
120.
Yeah, so the 22,000 will become 220,000.
Obviously, I'm not good with numbers, Your Honor.
Now, if that is the ratio that you are giving, I will have a problem on the definition of fine, because under Article 26 of the Revised Penal Code, fine is divided into 3 classes. We have when the fine is 200 or less, that is a light felony.
Yes.
When the
yes.
fine is between 200 to 6,000, then it becomes correctional penalty, less serious felony. If it is more than 6,000, then it becomes afflictive.
Yes.
Now, if you use the ratio of 1 to 100, then light felony will now be punished by a fine of 20,000.
We're aware of that. In fact, that was one of the issues which my team and I discussed at length.
Yeah, and that will be a problem. And definition and fine under Article 26 is not an issue here in this particular case. What I'm saying is that if you adjust the peso value, then what will happen with those crimes? I go back to my previous question.
Yes.
You will have to adjust.
That's why all these issues will have to be resolved anyway.
Yeah, okay. Another thing is this. We are talking about property crimes. There are really many property crimes. I can mention to you by reading my notes, no? But
Yes.
There are more than 20 property crimes that will be affected if we follow your jury under 315. But I'm more particular with a crime committed by a public official. In the crime of malversation under 217 of the Revised Penal Code, the penalty likewise, it contains incremental penalty.
Yes.
So that is not a property crime.
Yes. But
So, if we will now follow your jury, that the possibility of now of 1 peso should be 100, then the 12,000 and 20,000 in crime against crime of malversation will now become 120 to 220,000.
Yes, sir.
It's not. And any incremental penalty of any 10,000 in excess of 220,000 is an additional penalty equivalent to 1 year. No?
Yeah.
The same thing, eh?
Correct.
Okay. Are we not giving premium to corrupt officials?
well, in case of corrupt officials,
Because in order to be punished under malversation for that penalty, I think of prison mayor, minimum or medium, the amount now will become 120,000 to 200, in between 120,000 and 220,000. Are we not giving premium to corrupt officials, public officials?
yes. I submit, Your Honor, that these exceptions may be carved out from the general modification exercise. Because in case of malversation, there is another public interest issue involved there. He's a public officer.
Yeah, but what I'm saying is that if we change the money value, as you have suggested to 100, it's not only the crimes against property that will be affected. There are other crimes that will be affected, like the crime of malversation. We'll be giving premium to public officials who malverse the funds of the government for his personal use.
As I said, Your Honor, I think we can carve out exceptions
Yeah.
for those specific situations.
Now, who will tackle? Okay, there is a case. No, this was cited by another friend of mine, citing a case in 1983. Although the Supreme Court there was divided, entitled Solem versus Helm.
I'm familiar with that case, Your
Yeah.
Honor.
Did you cite that in your comment?
Yes,
Or
I
did you
did.
mention that? Okay.
Yes, I did. Solem versus Helm is 463 U.S. 277.
Yeah, so I will not ask anymore my good friend Joe Manuel.
I am sure Attorney Chell
No,
is very well
I just
prepared.
know. Because you cited that case, because in the case of the Supreme Court, in this particular case, the Supreme Court struck down the penalty imposed on the accused, because the penalty is not proportionate.
Correct, Your Honor.
The penalty is not barbaric, but the
Correct.
Supreme Court said it is not proportionate
Correct, Your
to
Honor.
the crime committed.
In fact, the Supreme Court in the Helm case provided 3 standards by which you can determine if it's cruel or excessive. Number 1, the gravity of the offense compared to the penalty. Number 2, the penalty imposed on more serious offenses. Number 3, the penalty as compared to those in other jurisdictions.
Okay.
Those were the 3 standards fixed
Yeah.
in Helm, Your Honor.
Yeah. But the facts there are not similar to the issue here in this case. Because the accused was charged with uttering of a false account or no account. That means
Yes,
that
Your
he
Honor.
was passing off a check,
Yes.
which is not at all a check.
Yes.
It's no account. And under South Dakota law, that is punished by a penalty of not more than 5 years or not more than $5,000 fine. That is
Yes.
the penalty for that particular crime. Now, the legislative body of South Dakota I mean, yeah, there was a law which was applied by that court, no, not the Supreme Court, that court, where that court imposed a penalty of reclusion perpetua or life imprisonment on the ground that the offender was a recidivist.
Yes.
Because he has been convicted previously for 6 crimes, not necessarily crimes against property, but crimes against persons. So, the lower court there imposed a penalty of life reclusion perpetua, life imprisonment, and not eligible to parole.
Yes.
Is it not?
Yes.
The Supreme Court struck down to Justice Powell that that penalty is harsh, extremely excessive, disproportionate to the offense committed by the accused. The reason is simple. He was already penalized for uttering a check, a bum check for that matter. Why would the penalty be increased to life imprisonment and not eligible to parole? Just because he is a recidivist. I think that law is not applicable here because there is a penalty already provided for by law, but because he is a recidivist, the court imposed a penalty of life imprisonment. That's why that law was struck down as unconstitutional, because clearly that is too harsh. In our jurisdiction, that will not happen because recidivism under Article 14 of the Revised Penal Code is merely an aggravating circumstance.
Yes.
It does not add to the penalty already provided for by law. So I think that case is not applicable to our case now. Okay? Do you agree?
Well, as an advocate, I think the spirit behind the decision of Solem versus Hell can be applied to the declaration of excessive penalties in the forms of long prison terms.
Yeah, okay. I have no more questions, Chief.
Justice
Thank you.
Leonian.
Thank you.
Good afternoon, Counsel.
Justice,
First, let me ask you, how is your client?
I beg your pardon?
How is your client?
Your Honor, I was appointed the official counsel only 10 days.
Okay.
I exerted efforts to contact, given, and I haven't had the opportunity to meet him, but I promise I will meet him as soon as I can.
So I understand that he is out on bail
I presume so, Your Honor.
and that this case happened sometime in May of 1991.
That's correct, Your Honor.
And the amount involved is jewelry.
98,000.
Worth 98,000. Now, Counsel, the year now is 2014. Is that not correct?
Yes.
Yes. And would you know if the revised penal code, in spite of its title called revised, labeled revised, what day or what date was it promulgated?
It was passed, I think, January 1 of 1930 and took effect
1930.
took
Now,
effect
the
1932.
date of the law, is that part of the law?
I beg your
The
pardon?
date of the law, the
The
date
date?
of promulgation of the law, is that part of the law?
Yes.
Yes. So there is in that particular act a last line which states when it was actually promulgated by both houses of Congress and signed by the President. Is that not correct?
I have not seen it, but I presume it does.
No, all laws, for that matter,
Yes.
has a promulgation date.
Yes.
Why is there a promulgation date?
So that it will be binding upon the public and also to show that as of that date, that was the intent of the legislature.
In other words, would you say that the date when the law was promulgated comes into play whenever there is a need for interpretation of that particular law?
Most definitely, Your Honor. We have to divine the intent of the lawmakers at that time.
Yes. You proposed a very interesting theory and one which I think should be taken seriously into consideration, that what we are doing in terms of this case, when there is a proposal to actually look at the values, is not simply to declare some part of it as unconstitutional, but what the Supreme Court is being asked to do is do what it does every day,
Yes.
which is to interpret provisions of the law. Is that not correct?
Yes. I've been wrestling with that dilemma for the past days and nights. I had
And
two options: attack the constitutionality of the law as my primary argument, or devise a way by which the Supreme Court can resolve the case by simply performing its basic judicial function,
Yes.
which is interpretative.
So if this is simply interpretation of the law, it is not material whether or not there is a party that raised the constitutionality of
Exactly.
certain proportions.
Exactly. That's why I adopted that position, so that we can avoid the procedural issues.
And in interpretation, there are two possibilities. One possibility is interpreting the law so as to avoid a constitutional issue. Is that not correct?
Yes.
Which means there, in that kind of approach to interpretation, then we will have to deal with constitutional provisions such as the one prohibiting cruel and unusual punishment. Is that not correct?
Yes, and also equal protection and probably right to bail.
And the other modality of interpretation would be simply ordinary interpretation, which means that the amount of 50 pesos in 1930 should be read as 50 pesos in 1930 today.
Yes.
Which means, therefore, that we take into consideration certain concepts like the purchasing power of the peso, inflation, and so on and so forth. Is that not correct?
Yes, and most critically, Your Honor, the legislative of the congressman taking the law as a whole.
Okay. Following either of these two modes of interpretation, of course, has its own problems. And one of it is, of course, the unintended consequences with respect to other provisions contained now in criminal statutes, whether mala in se or mala prohibita. Is that not correct?
Yes.
Yes. And therefore, of course, we have to take into consideration as to whether there are extraordinary salient facts of this case which the court must take into consideration. Is that not correct?
Your Honor, are you referring to the case of People versus Corpuz?
Yes,
or?
this Corpuz case. Such as, for instance, that it has already been 84 years
Yes.
since these values have been amended by the Congress. Is that not correct?
Yes.
Yes, and in terms of interpretation by this court, it is possible for this court to say that its extraordinary reading of the provisions of this particular law will only apply because it has been more than 50 years or 75 years since the law has already been amended. Is that not correct?
I would submit that is possible, Your Honor.
And the act of the court to look at the value now of 22,000 or 50,000 will not be applicable to certain provisions of law which are quite recent. Is that not correct?
Yes, Your Honor. Because
So it is possible that this court will say, will put a cut-off period, such as saying all laws that has not been amended in terms of its value for more than 75 or even perhaps 80 years, which now pertains only to the revised penal code, should now be read by the court in one way, so as to skirt the issue of unconstitutionality in relation to excessive punishment. Is
that's
that not
one
correct?
possible approach, Your Honor.
Yes. Now, let me go to a second point. What value are we going to use? Are you aware of two recent cases of this court promulgated by the 3rd Division? One is entitled DPWH versus Texon, and the other one is Heirs of Tria versus Land Bank of the Philippines, both promulgated on July 1, 2013. Are you
I'm
familiar?
not aware of those cases, Your Honor.
There is a concurring opinion there which explains the concept, the economic concept of present value.
Yes.
Would you know the meaning of present value?
I
Present
suppose the
value is a formula that is used not only by economists, but also by business, banks,
Yes.
and almost everyone in business, which uses inflation rate in order to approximate the value of a certain property given inflation.
Yes.
Yes.
In fact, Your Honor, may I point out that in the case of civil liabilities arising from wrongful death or tort, the court has not had any problem in adjusting the damages awarded to the injured party.
Perhaps you can take a look at the modality in the concurring opinion and see whether it is common or ordinary in business.
We will do that, Your Honor.
And that, therefore, it is not strange for any contemporary individual or average person to actually find out that in certain instances, assets are revalued, properties are valued, the purchasing power of the peso is taken into consideration, and so on and so forth.
In fact, it's not only strange, it is expected, Your Honor.
Yes, and this Supreme Court interprets provisions of law from the lens of the contemporary. Is that not correct?
Yes, as it should.
Which means, therefore, that it is not for it to be tied up to a certain period, let us say 1930s, for that matter. Is that not correct?
Yes, yes.
Yes, as a matter of fact, this court has ruled on the constitutionality of the Cybercrime Prevention Act, not using the lens of the 1900s, but using the lens of today. And in many of our separate opinions, we did cite Facebook, Twitter, and many of the modern phenomena. Is that not correct?
As it should, Your Honor.
So it is not extraordinary for the court to look at the context in terms of interpreting a provision of law.
No, not at all. On the contrary, Your Honor. The
Neither
court should...
is it extraordinary for the court to take into consideration disciplines which are already taken into account by business ordinarily in terms of their commercial transactions in order to make an interpretation of a provision of law. Is that not correct?
Yes, yes.
Yes. And in looking at inflation, there are usual ways of actually determining what the inflation rates are. Is that not correct?
I believe so.
Yes. For instance, consumer price indices. Of course, consumer price indices are available from 1948 to the present day. Is this not correct?
Yes, but our central bank started recording inflation rate data only in 1957.
That's inflation rate officially.
Correct.
But inflation rate can be derived from consumer price index. Is
Correct,
that not
before
correct?
1957.
Now, in order to compute from 1932 to 1948, it is also possible to use another price index, which is called the sectoral price index. Is that not correct?
I'm not aware of the sector.
Which is on particular goods that have been collated, such as, for instance, agricultural goods. 1902 to 1946, there are values to the price indices of agricultural goods. After all, during that time, we were mainly agricultural. Is that not correct?
Yes.
Well, of course, there is another way to impute inflation ordinarily used in business as well as in economic studies, and this is to use the gross domestic product changes or the gross domestic product implicit prices. Is that not correct? And I am sure that you are going to put this in your memoranda when you submit it.
Well, Your Honor, for me, the best proof that the courts can modify or adjust or harmonize the figures as between then and now is the constant changing of the amounts in damages awarded by the courts in wrongful deaths. Okay. When I was in law school, it was 2,500.
Well,
now it's 250,000.
Yes, that too needs to be reviewed because we are using standard figures rather than the survey of annual family incomes and expenditures. But that is another matter altogether.
But the point is, it is within the power of this court to do it.
So what you are asking this court to do is to read law not only from the point of view of logic, but to read law from the point of view of context or contemporary circumstances, using disciplines that are out there which are used by the common person. Is that not correct?
Definitely.
Yes, and that includes economics. Yes. That includes finance.
Yes.
That includes statistics. And in all three subjects that I have mentioned, it is usual to use real value or present value. Is that not correct?
I presume so, Your Honor.
And if this court, therefore, can take into consideration Facebook or Twitter, then it can take into consideration those usual concepts also in determining the interpretation of a value in the revised penal code.
Yes.
Yes. Next, of course, there will be technical difficulties in terms of implementing the unintended consequences of this interpretation. Is that not correct?
I expect them to be.
Yes. Now, of course, you are going to tackle these technical difficulties in your memoranda to assure this court that it is a doable interpretation and will not unduly infringe upon the prerogatives of the executive and the legislature. Is that not correct?
I will try my best, Justice.
Yes, and perhaps not only you, but because they are listening, the Solgen and the Amicus
I am
can
confident that they will be helping out.
Yes, and the reason why we have taken Amicus, especially Professor Tadyar from whom I learned my criminal law in 1930.
I also learned under Professor Tadyar.
Yes, and of course,
Yes.
Dean Chel Diokno, among others, are going to assist you in this regard.
Yes.
So what is at issue here is the power of the court to interpret.
I believe so.
And of course, you have to define what it is to interpret for this particular court, because this is not a court in the 1930s. Is that not correct?
Yes.
Yes, and we do not look as coming from the 1930s. Is that not correct, counsel? We look very young, and we are all from this generation. Is that not correct?
Absolutely, Your Honor.
Yes, and there are generations of this court that are appointed in accordance with the Constitution precisely because the Constitution is a living document. Is that not correct?
Yes.
And so are laws.
Yes.
And so are justices of this court now to take into consideration the contemporary context of this provision.
Yes.
Is that not correct,
Yes.
counsel?
Yes.
Thank you. That is all for you.
Thank you very much, Justice.
Justice Abad.
Good afternoon, Justice Abad.
You are not talking, from what I gather from what you said, you're not talking of declaring Article 315 unconstitutional, but rather that you would ask the court to adjust the penalty for property crimes by judicial construction of the law to apply what the legislature intended when it passed the law in 1930. Is that correct?
I have the primary argument that the Supreme Court can resolve the case solely on statutory construction. However, if the opposite view prevails, then I believe that the subject provisions are unconstitutional.
Okay. Now, in construing the penalties provided by the 1930 Penal Code, do you think the court would have sufficient data that it could take judicial notice of the purchasing power of the peso in 1930 compared to today?
Your Honor, we tried to look at materials regarding the legislative discussions on the 1930 revised penal code. We were not able to find any.
Well, I took a look, and unfortunately, unlike the present, we did not conduct any statistical survey that would show the buying power of the peso in 1930. There was none.
In fact, Your Honor, in 1930, I hazard to say that most people had no concept, much less a clear understanding of what inflation is.
Yes, that's correct. Now, but based on a 1932 American Chambers of Commerce publication, rice was priced at 4 pesos 50 centavos per caban. You know?
We have those prices, Your Honor.
In 1932. That's about the price of, what do you call that? Popsicle, no?
Yes.
Now, at present, the regular variety of rice is priced at about 1,800 pesos per caban, right? If we use this as basis, the 100 pesos today would be the equivalent of only 25 centavos in 1930. You can imagine that? Huh?
Yes.
Now, but economists would find that information too little for establishing the purchasing power of the peso for that year. Now, there was no official, from what I gathered, there was no official determination of the purchasing power of the peso in 1930, nothing official. But we have since adopted a better basis for determining the purchasing power of the peso today compared with previous years. There's a government agency, now the Philippine Statistical Authority, formerly the NSO, which gathers from the marketplace the average prices of a basket of things, like rice, sugar, fish, meat, school supplies, and other consumer products. NSO then determines through this basket of consumer goods, the purchasing power of the peso today in relation to previous years. Although this practice of getting this data began only on a regular basis, began only in 1957, NEDA has a record for the consumer price index taken in 1948, which Justice Leonen was mentioning.
Yes.
But that's an isolated one. The next one was in 1957. Now, based on this, the PSA or NSO told me when he wrote them a letter, that the 1 peso in 1948 is the equivalent in purchasing power of 103 pesos today. Okay. So, let us forget about 1930 because there's no data for that. And just consider, as you proposed, today's equivalent of the 1 peso in 1948 based on the official statistical data. If the court uses that data, it would not be guessing. It would be relying on empirical evidence. Now, last week, my wife asked me to buy something from the supermarket, which she usually does. So, and then I came across, one of the things I bought was coconut cooking oil. As a matter of fact, I brought it with me. Here.
That's very healthy, Your Honor.
Yes. That's a half-gallon coconut cooking oil. That's the same cooking oil they're using in 1930. Do you know how much this costs today?
I'm sorry, but my wife doesn't ask
Well,
me to
it
go to
costs 203 pesos. 203 pesos. Do you know how much this would cost you in 1946? Based on the purchasing power of the peso in that year? Only 2 pesos and 3 centavos. Do you know? You could pay for it with these 2 pieces of 1 peso coins. There, 1 and 2. And the 3 centavo coins. But 3 centavo coins has too little value. There is no coin equivalent today for 3 centavos, so we can forget that. But today, as we said, you need 203 pieces of 1 peso coins to pay for this cooking oil. This box. May tapong pa rito. You see, there is a great difference in the prices. Do you agree between 1946 and today?
Your Honor, your visual illustration merely highlights the absurdity and injustice of the numbers in the revised penal code.
All right, let us assume that, let us say that someone gives me 2 pesos, this one, and 3 centavos in the year 1946. Let's say we are in 1946. And he gives me 2 pesos to buy half-gallon of coconut cooking oil, this one. Do you follow?
Yes.
But then I swindle him by pocketing the money. Will you let me tell you how long I will stay in jail for that?
2 pesos, Your Honor?
Yes. A maximum of 6 months.
Yes.
Under Article 315 of the Penal Code. But suppose we are back to 2014, today. And I'm the one who gave you the equivalent. 203 pesos. You follow that?
Yes.
Then I ask you to buy for me that half-gallon of cooking oil. Yes?
Yes.
But you pocket the money instead. You understand?
Yes.
May I tell you how long you will stay in jail for it, maximum?
How long, Judge?
2 years and 4 months under the same Article 315. I pocketed the price of half gallon of cooking oil in 1946 and got only 6 months. Applying the same law, you get 2 years and 4 months maximum. To be honest, would you agree that the same law favored me over you?
The one with the lesser penalty was favored.
Yes, the same law treated us differently. Do you agree?
Exactly.
Whether it is constitutional or not, the same law distinguished between the two of us even when we committed the same crime, correct?
Yes.
Now, for 82 years, the court has always computed the penalty for estafa based on the amounts that the legislature pegged to the value of money in 1930, correct?
That's right.
It has never departed from that practice in the last 80 years, according to Justice Leonen, correct?
Yeah. 84.
Your position is that the position of the government, the Solicitor General, is that the practice has so hardened in 80 years that it is no longer proper to change it. Now, I remember when I was still a child that my grandmother always insisted on using charcoal flat iron. You know, many of you have not seen that. It's a big thing. You put the burning charcoal inside. It hits the iron, and then you use it for ironing clothes. Okay. She always quarreled with my mom, who said, you should already use the electric flat iron. But he would not agree because she had always ironed clothes that way all her life. Since 1895, when she was about 20 years old. Oh, 1895, yes. Now, would you agree that her lifelong use of charcoal heated flat iron has also hardened, that she doesn't want to change? And she could not adjust to something better? Well, this actually reminds me also of Dr. Joseph Lister of England. He introduced antiseptic surgery in 1980. This means that doctors should wash their hands and their instruments before delivering pregnant women. Even after Dr. Lister proved him right, thousands of mothers continued to die from infections during childbirth. Why? Because most doctors at that time would say, looking at their unwashed hands, say, we have always done it this way on these mothers. And they died. It is the position, is it your position? Well, it is the position of the Solicitor General that the court should close its eyes to the fact that the value of the peso in 1930, when the penal code was enacted, has greatly depreciated because we have been doing this way all these 80 years, right? That is their position. Now, I'm going to another point. You said that adjusting the penalties, well, the Solicitor General's office said that adjusting the penalties to cope with inflation will amount to judicial legislation. Do you agree with me that there's their position?
Yes, that's their core position.
But are you not aware that the Supreme Court has a long history of adjusting amounts fixed by law to cope with the realities of inflation? Are you aware of this case?
Definitely, absolutely. Not just the Supreme Court.
Yes. When the Code Commission drafted the Civil Code in 1949, it fixed the minimum civil indemnity for debt to 3,000 pesos. I'm going to read it. Article 2206 of the Civil Code. The amount of damages for debt caused by a crime or quasi-delict shall be at least 3,000 pesos even though there may have been mitigating circumstances. Okay, that is the law, correct?
Yes, 2206.
That's what the law commands, correct?
Yes.
Now, Congress has never amended it to raise the amount. It never amended this provision of the Civil Code to raise the amount of minimum for civil indemnity. Now, so if the trial court awards 10,000 pesos today in civil indemnity against the accused, that would be in conformity of the law, correct?
Correct.
Because the law says minimum is 3,000. So if they pay 10,000, that will be. Well, do you agree?
Yes.
Well, wrong answer. Your answer is wrong. Because the Supreme Court, interpreting the law in the light of inflationary movement of money values, set a new minimum of 6,000 pesos in 1964. Are you aware of that?
Yes, what I meant, Your Honor, was that 2206 fixed the amount at 3,000 at a minimum. And subsequently, the Supreme Court has, on several occasions, increased that minimum.
Yes.
Such
well,
that today it's around 250,000, I believe.
Yes, the Supreme Court raised the statutory
Correct.
minimum to 12,000 in 1968, 30,000 in 1983, 50,000 in 1970, and most recently, 75,000 in 2009. Would you know the court's justification for such adjustment?
Inflation, Your Honor.
Yes, it regarded as inequitable on account of inflation the award of a measly 3,000 pesos to the victim's heirs. Would you agree that the Civil Code stands on the same footing as the Penal Code
Yes.
in force and effect?
In fact, the Civil Code is subject or below the Criminal Code because in crimes, all
Yeah,
doubts are
yes, but
resolved
both
in
of
favor
them are laws.
Yes.
Is one law stronger than the other law?
No.
No, they are the same laws. They are mandated by the legislature. But the Supreme Court has made those adjustments, you know. This is not judicial legislation. And do you know what the Supreme Court's justification for this, as you said? It said in Pantoja, yes,
Yes.
that the difference between the value of the present currency and that at the time when the law fixing a minimum indemnity has changed.
Yes, Your Honor.
That's what it took the Supreme Court to adjust the amount fixed by law.
People of the Philippines versus Pantoa, GRL 18793, October 11, 1960.
Okay, now, Justice Leonen raised a point about the possible confusion. Even, I think it was even also raised by Justice Peralta, that this will brought about in the other cases as well. Right. Considering that they would be dealing with so many crimes, the penalties for which are pegged to the 1980 value of money and property, including malversation of public funds. Actually, that's government property also.
Yes.
That person takes from the government. In that sense, that is a property crime. Okay. But such adjustment would be simple arithmetic. The value of money or property today divided by 100 equals the equivalent money or property value that the legislature had in mind in 1930. So, uniformly applying the 100 to 1 peso ratio, they will just divide the present charge by 100 and then be able to determine the equivalent in 1930. So, with that, a property worth 50,000, if stolen today, would be the equivalent of 500 pesos property stolen in 1930. So the 50,000. The 50,000, if divided by 100, will be 500 pesos. Stolen, value of property today is 50,000. If it's stolen today, then its equivalent will be 500 pesos in 1930 and would draw the corresponding penalty prescribed by law. It will be the same for a 50,000 robbery. a 50,000 estafa, a 50,000 malversation of public funds that Justice Peralta refers to, a 50,000 arson, and a 50,000 mischief. There will be no confusion. Just simple arithmetic. And everybody will be able to determine what kind of adjustments are going to be made. The conversion formula will maintain uniform levels of legislative indignation or outrage over the wrongs committed based on money or property values. Okay, that is all for me. Thank you.
Yes, Justice Perez.
Afternoon, Justice Perez.
Good afternoon, Attorney Mario. Let us say that a certain court, in the exercise of discretion, or this court, in the exercise of its discretion, determines, as you suggested, that the ratio would be 1:100.
Yes.
What would be the ratio 5 years from now?
It depends, Your Honor, on the degree of inflation that may have occurred 5 years from today.
In other words, the penalty for theft and for similar crimes would depend on what time the crime was committed.
Your Honor, please. In fact, if we will adjust for inflation, the passage of time will be irrelevant because we will go back to the 1930 values. The moment you allow time to affect the value of the peso and thereby the article subject of the crime, then it will impact on the penalties. It will change what I call philosophy of proportional retribution. I'm sorry.
Or whatever it is called, the penalty will vary from time to time.
Yes.
And the determination of that varied valuation is an exercise of judicial discretion, or determined through the exercise of judicial discretion, is it not?
Similarly as in civil liabilities.
Would that then, are you now proposing that our laws on property will no longer be determined by the Book of Crimes and Penalties, which is the civil law manner, but rather the common law manner of determining the penalty by the exercise of the discretion of the judge? And are you prepared to do that or to propose that? Shift from common law to civil law.
I used to teach criminal law, and I'm biased in favor of our criminal law. I'm not familiar with the common law concepts. I think our judicial system and the bar are far more familiar with the Código Penal principles. Although, as was mentioned, we should all progress in terms of thinking. I would be open to common law adjustments.
And that can be done by the court?
Definitely.
Okay.
This is the Supreme Court.
Please expound on that in your memorandum. Also, another point is, don't you see any difference between a civil law case or a civil law matter and a criminal law case or a criminal penalty matter when you go into the matter of determining present value, etc.?
The substantial difference, Your Honor, is that any doubts should be resolved in favor of the accused in a criminal case. So that if you are willing to adjust penalties in a civil case, more so should you be open in adjusting the values which will favor the accused. Because that's a principle of statutory construction.
And you interpret the provisions of the revised penal code in the same manner that you would interpret, for example, a civil law contract, what the respective rights and obligations of the parties in a civil law contracts would be?
Well, in a civil law contract, Your Honor, the presumption is that both parties are on equal footing and they had full knowledge, full resources to give their consent. So they're treated equally by the law. However, in criminal law, since the individual is faced by the array of powers of the state, all doubts are resolved in favor of the individual. Moreover, as I said, the right to liberty is enshrined in our Constitution. After the provisions on national territory in the Statement of Policies, it's already the Bill of Rights. And the first right there in the Bill of Rights, Article 3, Section 1, is the right to liberty.
To another point, and I go back to the first statement of Justice Peralta when he said that should not all the things that he said before us be addressed to the legislature. And you said that it will be a very long wait, as evidenced by what happened already, for us to anticipate or what the legislature would do. Because you said that this has been a pending matter before our legislature, and yet until today, nothing definite has been done by the legislature. Okay. Assuming that you would not debate really if the matter is placed before the legislature, only that it takes the legislature longer than you expect this court to take in deciding the matter, would you accept the proposition that for the courts to go ahead and apply the provisions of the revised penal code, impose in its decision the penalty mentioned in the revised penal code, but say that before this person goes to jail, he can be out on bail until the legislature comes out with a definite law?
Your Honor, as I said, I was trying to think out of the box in looking for solutions.
I'm also thinking out of the box.
One of them can be that this decision will take effect after 12 months. If within those 12 months the legislature doesn't do anything, it'll take effect. But I'm concerned about how that will be taken by the legislature.
The legislature does not have any concern there because it will be the court which will say that you are allowed to go on bail in the meanwhile.
In fact, Your Honor, on this issue of legislative prerogative, presuming this honorable court adjusts, modifies, or synchronizes, harmonizes the penalties, this does not stop the Congress from passing another law in 2 weeks' time, expressing its true intent. So there is really no harm, quote unquote, if this Supreme Court proceeds with that.
Which to me is the proper way of solving this controversy, for Congress to solve it. Because it's a
in an ideal world, the Congress should.
Duty.
In an ideal world, the Congress should.
Yes.
But they haven't.
And, well, thinking of the box, may I repeat, we both are loyal to the principles of constitutional law, the principles of the separation of powers, etc., and at the same time, allow Congress to do its work. Respect the law as it is written. Let us not wrestle with finding the proper monetary value of what is stated in the revised penal code. Yes, apply it, but at the same time, give the Congress the chance to correct what I think is agreed upon as really something that needs to be corrected.
Yes.
Anyway, just thinking out of the box.
Thank you, Justice.
Justice De Castro.
I'll go back to your proposition or the rule of statutory construction that you cited earlier.
Yes, Justice.
That a law should be interpreted in its entirety. No?
Yes.
You said that. So if we grant your position in this case,
we need to apply this. This will become a judicial precedent.
Yes.
So that can be invoked in other cases.
Yes.
Like if we take into account Article 39 on subsidiary penalty, which imposes 1 day imprisonment for each 8 pesos of fine, which the accused is not able to pay. So that means that we need to adjust also this provision of the revised penal code on subsidiary penalty by parity of reasoning.
Your Honor, when I was given this assignment, the instructions I got was that the focus will be on the penal provisions of property crimes. I understand that if we change the values wholesale in the entire revised penal code, there will be problems. But my proposition was actually focused on the penal provisions of property crimes.
But the court needs to find out what will be the implication of a ruling that will make an adjustment in the penalty based on inflation in relation to not only to future cases but also to past cases.
Yes.
Already decided by the court. So don't you think this will open up the filing of petitions to invoke the same benefit that an accused will enjoy based on a decision that will favorably act on your proposal?
In fact, Your Honor, the settled rule is that all favorable decisions of the Supreme Court can be given retroactive effect if possible. Yes.
Precisely, that is the point. The decision of the court based on the civil code will be considered part of the law of the land.
Exactly.
And therefore, the rule that any favorable law will benefit or will have a retroactive effect
To all.
to all accused,
Yes.
or to all persons who are convicted of a crime.
Yes.
Okay, so that means that the court will be swamped by petitions invoking the same privilege or benefit.
If I may, taking off my cap as a lawyer for counsel to official, can that situation not be addressed by an administrative memo from the Supreme Court instructing the trial judges to do A, B, C, D in furtherance of the precedent that will be set by this court, so that we will avoid the filing of cases by accused?
But you need to contend with the constitutional provision or the constitutional guarantee of equal protection of the laws. We cannot say that this will apply only to the case of Corpuz and not to other cases.
Precisely.
Because that will now mean denial of the equal protection of the laws.
Yes.
So we need to find out if we make a ruling now adjusting the penalty because of inflation, this will also be invoked by other persons who were convicted on the basis of the provision, the literal provision of the revised penal code as they stand now. And there may be a problem about what will be the inflation rate as of a particular date. For instance, someone was convicted 5 years ago or 10 years ago. So will the court now be called upon to find out what was the inflation rate as of the date that the crime was committed for persons serving sentence in jail now? Will the court have to go into that, or is there a possibility, a great possibility, that petitions will be filed by those convicted under the provision of the revised penal code invoking this favorable ruling of the court in the Corpuz case? How do you propose that the court deal with this problem, considering the constitutional protection of equal protection of the laws?
As I mentioned earlier, perhaps the Supreme Court can issue a memo to the trial courts instructing them to apply the judicial precedent that will be established in People versus Corpus.
prospectively?
As long as the decision will affect favorably an accused, it will be applied retroactively.
So precisely, so those serving sentence in prison now may invoke this
Yes.
ruling of this court.
Yes, yes, yes.
And you see no problem with that?
Your Honor, there are problems, obviously, but with due respect, we cannot be stymied by these problems and be rendered paralyzed just because we think there are too many questions that need to be addressed. These questions will have to be addressed by the Congress anyway. With due respect.
So we may have to deal with the question of what was the inflation rate, say 5 years ago, 10 years ago, because those convicted of a crime, say 5 years or 10 years ago, will have to invoke this, may invoke the same ruling, and
Yes.
And the court may be called upon to determine the inflation rate of a
Your Honor,
as of a
please.
particular date.
Your Honor, please. As you know, I've handled cases in the Supreme Court, and many of the cases are extremely complicated, far more complicated than this. In fact, in the Meralco case, the issues there are mind-boggling. And yet this court has taken the challenge and dug its heels and gone into the issues in the Meralco case. The Meralco case, I'm not trying to belittle the issues there, but it merely involves money. Here, what is involved is personal liberty. And I'm very confident this honorable court can overcome those problems.
I'm not saying that it's wrong or correct. What I'm just trying to point out is that we need to be prepared
Yes.
for the implication of a ruling that will accord to Corpuz this favorable treatment, which the other persons convicted before may not have not been afforded prior to a ruling that will be rendered in this Corpuz case, assuming that we favorably act
Yes, sir.
on your proposal. And it's not only the past cases that may pose some considerations on the part of the court, but also future cases.
That's right.
How do we deal with future cases? Will the court now be called upon to periodically examine the inflation rate?
Not necessarily, Your Honor. Just like in the civil liabilities issue, the court fixes an amount. And if the court feels that there is no need to change that amount, it won't. But the moment the court feels that it needs to change the amount and the legislature has not done anything, I believe it's within the sound just discretion of this court to apply the 1930 values. I am absolutely convinced of that.
My point is just that the ruling in the Corpus case, no, if ever we issue a favorable ruling in the case of Corpus, will have far-reaching implication.
I understand.
Not only to past cases decided by
future
the
ones.
courts, but also to future
Yes.
cases. And the
Yes.
court must be prepared to anticipate all of these consequences.
If Your Honor, please, if the remedy is provided by Congress, the same problem will have to be addressed by the court. If the Congress suddenly next week says, all right, all the values will be reduced by this much, we'll still have to face the issue of how it will apply to past and future cases. It's exactly the same thing.
I have no further question.
Justice Velasco.
Justice Velasco, good afternoon.
Good afternoon, Counsel. You have made your position clear that you just want to apply the intent of the lawmakers when they fix the different penalties based on specific amounts. Is that correct?
Yes, Your Honor.
And that you're saying that in 1930, when they fixed these penalties, vis-a-vis the different amounts laid down in the different provisions in the revised penal code, they took into consideration the value of the peso at the time, correct?
Yes, in fact, I believe at the time they did not even have an inkling that the peso value will change substantially.
Right. They also fixed the penalty for, say, murder at the time.
Yes.
And would you agree that the penalty that the lawmakers intended, that the penalty prescribed for the crime of murder should be a lot higher than the one that they have prescribed for the crime of estafa?
Yes, at that time.
At that time, okay. So it's your position that if we adjust the penalty now prescribed in Article 315 for estafa, then we are merely applying what the Congress or the lawmakers intended at the time.
Absolutely.
All right. Is there any law or legal provision that where Congress allowed the adjustment of, say, the amount based on extraordinary inflation or deflation? And I'm not saying we are we are specifically concerned only about a crime. It may be civil law or other laws. Is there any specific legal provision where Congress allowed the adjustment of the amount involved, say, in a contract based on extraordinary inflation or deflation?
Well, there is an express provision in the Civil Code with respect to rebus sic stantibus, I think it's 12-something, extraordinary inflation. But as far as I know, the Supreme Court has been very, very reluctant in applying that. But in terms of laws, there are cases which have taken into account the change in inflationary values of the peso. I can submit that in a memorandum, Your Honor. There are many of them.
So you're referring to Article 1250 of the Civil
That's
Code.
correct, 1250.
Right. So
1250.
But Congress allowed the adjustment only on the amount covered by a contract, right?
Yes.
And that is civil law.
Yes.
And are you saying that we can also apply that by analogy to criminal law?
In fact, what I'm saying, Your Honor, is that the intent of Congress in 1930 was to apply this hierarchy of penalties to this hierarchy of crimes. We are not changing the intent of the law. We are merely synchronizing the values to preserve, implement, and effect the congressional intent. I'm not even saying that the court will overtake the legislative prerogative and insert its intent over that of Congress. The congressional intent is clear in 1930 as seen from an examination of the entire revised penal code.
So you're saying that because of the change in the situation then existing in 1930 and those existing now at present, that there is a sort of doubt now created with respect to the value of the amount, possibly subject of estafa. Is that
Yes,
what
Your
you're
Honor.
saying? That's why there may be now a need to interpret the provision in question?
Yes, Your Honor. In fact, even if it involves the examination of a law on the basis of constitutionality, changed circumstances may allow it. There are cases which hold it, Central Bank versus BSP, wherein the Supreme Court said and applied the principle of relative constitutionality. A law may be constitutional under a certain set of circumstances and may be unconstitutional under another set of circumstances. As was said very brilliantly, the law is alive. It is not dead.
Correct.
So it moves, it dances with the developments of time and history.
Okay, you have also underscored the fact that it's a settled principle that any doubt should be construed or in favor of the accused, correct?
Yes.
Okay, and I guess if there will be a favorable ruling in this case, then a a lot of convicts in our penitentiaries will probably petition us that this be applied to them. And I guess Justice Abad, who's the main proponent of jail decongestion, will be very happy that
Yes.
a lot of convicts will be released based on this possible favorable decision of the court. Okay, but what I'm really concerned about is how we really fix the equivalent of the peso in 1930 vis-a-vis what should now be the value at present, and how about in the future. So because the Supreme Court may not be the only one that will be determining this in the future, because changes may change and the value of the peso may change, or so the trial court judges may also will be faced with the problem as to how to compute the penalty to be imposed on the accused. And so what formula do you suggest that will clearly guide a trial court judge in fixing the penalty to be imposed on the accused?
Your Honor, I'm not suggesting any formula. What I'm saying is the court today can fix an amount, say 100 to 1, after consulting with the proper financial, economic, business experts, and then apply it accordingly.
That is the problem, counsel. If you are not unsure of the formula, then we are also unsure of the formula, because you're aware that many lawyers and probably a number of magistrates are not very good at mathematics, and they may just come out with different penalties for a specific amount that was a subject of swindling. So you've got to tell us how we'll go about it. I tend to agree with your position, but there is really an extreme difficulty in the determination of the what is the present day value of the amounts in 1930 vis-a-vis those obtained
Your Honor,
now.
please. I am certain it will not be difficult to establish the value of the peso today as to the value of the peso in 1930. I am absolutely sure any economist can easily do that.
So what do you do? We will ask an economist to inform the court as to
Well, Your
the
Honor,
formula we will use?
It's very common in the case I handled here with respect to the spilled gas in Bangkal. We resorted to experts. Here in Meralco, we resorted to experts. We are lawyers and we are not equipped to deal with areas that require expertise, but certainly we can tap experts. It is not a problem.
You're aware of the Valentine scale of values?
I beg your pardon?
The Valentine scale of values, which were used in determining, in resolving disputes regarding obligations during the Japanese War?
I've heard of it, Your Honor.
Yes, and they have to conduct a study, and they took into consideration several factors before they arrive at this scale of value. So that is the difficulty, I think, that is facing the court in case the majority would be inclined to issue a favorable ruling here in this case. So we just don't know how to proceed from here, counsel. So you have to supply that, and I hope you can put that in your memorandum.
We will. Thank you, Your Honor.
Yes, Justice Bersamin.
Justice Bersamin.
Good afternoon, Attorney Bautista. How do you wish to be called, Professor or Attorney Bautista?
Sir,
You are in the academy also?
I used to teach, not anymore.
All right. Now, I seem to have heard you say that you also taught at one time criminal law. Did my hearing,
That's
was
right.
my hearing right?
Criminal law in the Ateneo School of Law.
Okay. Now, it is very
Although I'm
ideal.
from UP.
The better school.
Yes.
I'm not from there, but I am in the best school. Okay.
Yes, Your Honor.
Let's talk about a principle that I know is very, very general or very, very universal in criminal law, the principle of definiteness. And by that I mean that there must be certainty Because this is some law that always affects almost everyone in the territory.
Yes,
You agree with that?
absolutely.
So there must be no uncertainty in the law.
Yes, especially in criminal law when it comes to
Generality.
penalizing. Yes.
Okay. Now, let us look at these property crimes, where the amounts are very, very material in the
Yes.
determination of how should a criminal be punished.
Yes.
If this amount was in any way uncertain at any given point in time, would that satisfy this requirement of specific definiteness?
No, in fact, that is one of my main arguments, that because of the passage of time and inflation, the penalties imposable on property crimes have become flexible and accidental and unintentional.
All right.
Contrary to the intent of the framers in 1930.
So we are agreed on that. I think no one disputes that.
Yes.
The law that is a criminal or penal in character must be very clear about what it punishes,
Yes.
so that the criminal or whoever runs in with that law will expect to be treated according to that law.
Yes.
Okay. Now, your argument today seems to be that when the letter of the law, like a property crime, states a specific amount, that letter of the law could be bent in order to make it attuned to the value that is no longer there but was fixed in 1930.
Yes.
Is that your point?
My point is precisely the amounts today have to be synchronized to match the values in 1930 so that the penalties will be fixed. Otherwise, as clearly illustrated by Justice Abad, the penalty for stealing a cavan of rice in 2014 will be far, far more severe than stealing a cavan of rice in 1930, which should not be. Precisely.
All right.
The adjustment is intended to promote the definiteness of the crime.
So here is now a situation which somehow varies from your initial point about specificity or definiteness about a term of the law,
No.
a penal law. Because you are now saying that at a certain point the value may be different.
Yes, but the penalty should be measured on the value of the article in 1930.
Yeah, but we know that value in property crimes is always dependent on market.
Precisely.
Market.
But at that time,
All right. If you agree with me on that, let me go further. You are also a litigator. You have defended several cases. And I assume most of them, or some of them, may have been property crimes.
yes,
Yes. In your experience, in the experience of all lawyers here, we always have, as the start of a criminal prosecution in court, the filing of an information that makes allegations of ultimate facts regarding the elements of the crime,
including the amount.
including that amount.
Yes,
All right. If that is so, you have two sides to that information, one the prosecution side and the other the defense side. You also accept that.
of course.
And if it was the prosecution that should go forward with its evidence first, it would certainly include evidence on the value, not letting that allegation stand alone, but must prove the value at that particular point alleged in the information.
Beyond reasonable doubt.
You agree with that?
Yes,
And the defense, during its turn to present evidence, will have also the freedom to dispute or rebut the value that was established by the prosecution. You also agree with that?
if the article involved is not in pesos, you have to prove the value of the article.
Whether in pesos, in dollars, or in rubles.
Yes, but what I mean is if the amount embezzled is 100 pesos, you don't have to prove the value of 100 pesos. But if you embezzled, say, a pair of
So,
shoes,
do you mean to say that the accused will just accept what is alleged as
No.
the value? You must demand
Of
proof.
course.
If you were the defense counsel, do
Yes.
you not do that?
I do that, Your Honor.
Okay. So the defense will have to disprove also the value.
Correct.
Has that opportunity. If the defense does not know that, it forfeits the right to dispute the value, which is based on market value.
That's correct.
That's right.
That's right.
So where are we then in this case? Did the accused not come forward with any evidence to show that the value was only 100 pesos instead of the 98,000?
I understand.
You are not aware of the facts of this case?
I am aware of the facts. I understand that the accused did not.
Did not do that?
Yes.
Why not? Because he accepted the value of 98,000, knowing that if the crime was to be proved beyond reasonable doubt, he would be punished for 98,000.
Yes.
He did not do anything?
Yes.
Okay.
If Your Honor,
If he
please.
did not do anything, can you blame the prosecution for insisting on 98,000 to be punished according to the revised penal code based on a value that was there since 1930?
Definitely, Your Honor, I'm not blaming anyone. We are lawyers, we are advocates. The prosecution has to do the job. The counsel for the accused has to do their job. So it is expected that the prosecution will insist that the amount of the jewelry is 98,000. Now, apparently the accused Corpuz did not question the amount. For what reason, I do not know. But
Well, it's like this. Usually in estafa cases, we have receipts where the value is stated, more or less. We assume that the accused is stopped by his signature when he signs that receipt.
as long as he did so knowingly and willingly.
Yes.
Yes.
But I also practice law, and every time I had a case like that, I always contested the value that appeared on paper, despite the signature of my client.
Definitely.
All right. Maybe next time, because I do not yet know where, on which side I will vote in this case, if I will ever vote. Maybe when you will have a criminal case, defending a criminal, an accused, in a property crime like this, make sure that all the facts will be there, all the details, the statistics, so that there will be a time when that case will reach the court and the court will be better equipped to look at your urging.
Yes.
Okay. Value is an element of the crime, the property crime. We also are agreed on that.
Yes.
And value, if it is an element of a crime, is something that can only be defined by the Congress. Don't you agree with that?
Yes, and the value was defined by Congress in 1930.
Yes.
Yes.
And that value is a face value. It does not mention anything about market.
At the time, as I said, I think it is safe to presume that the Congress was not even aware of inflation.
Yes, yes. Because Congress is aware that if it is going to pass a penal law, that penal law must be clear, definite about the details.
Yes, Your Honor.
Yes. And surely, if an amount that was fixed at 100,000 in 1930, if the Congress was present enough, Congress would have known that that amount in 20 years' time, 30 years' time, 50 years' time would not be the same.
Yes.
It was aware of that.
Yes.
And it did not say anything at all about those changes that the future will bring into that law.
Well, the congressional intent of the Congress in 1930 was expressed by positive action and expressed in a legislative act, whereby they designed and structured the revised penal code with its proportional hierarchy of retribution. That was a clear, deliberate, intentional expression of intent. Now, for 84 years, the Congress has not done anything. And from there, you try to divine that their intent is to allow the passage of time to affect inflation. As between the positive, categorical, expression of intent in 1930 and the passive, implied admission intent of the Congress now, I think the intent of the lawmakers in 1930 should be far more compelling.
All right. In statutory construction, we have what you call the law of the statute. And the law of the statute is no more, no less than the intent.
Correct.
The legislative intent. But you see, the problem with intent is it is only the courts that will say what that intent is. Congress may have a different view of things, but if the courts do not read the same, are not on the same page with the Congress, that law of the statute will be different
Yes.
in the written decisions of the court.
That's pursuant to the checks and balances and the separation of powers
Yes.
and the basic functions of the
Now, do we talk, when you say about intent, do we talk about an 84-year-old law of the case?
Yes, because the intent there was expressly, categorically, unequivocally expressed.
Okay, what do you think should account for the failure of the legislature in the 84 years that this revised penal code has been there, not to change these amounts that have been made or written in the law? What? Neglect, according to Justice Abad, or ignorance, or unconcern? What is the reason? May you not give to Congress the benefit of the doubt and say Congress does not see yet any reason to change the amount?
As I said, the clear congressional intent was expressed in 1930.
Or congressional failure or congressional
Yes.
omission. But we also have a statutory construction rule. What is omitted is not merely omitted, it is intentionally omitted. Inaction, legislative reluctance.
I think it's clear, as I pointed out, that even this Congress has the intent to change the law. It just doesn't have the wherewithal to do it. I don't know why.
So it was the intent to change the law. Is that what I heard you say?
They already expressed their opinion
Their opinion.
that
but they
the
have
laws
not
today are excessive.
excessive.
They said
That
it.
is their opinion. Now, do you want that opinion to carry over to us and define their intent based on that transmission?
No,
I don't think that is possible.
well, it's an admission on the part of Congress because they filed that in a comment before this court.
Well, anyway, I believe you are very, very aware of this problem, and when you have a property case, a criminal prosecution involving property, you will inform the trial court so that the trial court will do its job, and then that case will ultimately land in our laps, and probably we will have the equipment to exercise our judicial review. Okay? Because
sir.
I don't think, I am not saying I will vote against your side, but I don't think at this time I have been persuaded to go back to 1930, change that law, and say that is the intent of the Congress. Today,
We are not, my proposition is not to change anything. My proposition is to adopt, implement the original and genuine intent of the 1930 legislators.
Anyway, I just want to mention also here that a while ago, when you were having the dialogue with Justice Abad, you were also saying that the court felt free to increase the 3,000 pesos fixed for death indemnity and raised it to the present value now of 75,000.
Because the law said minimum.
Yeah, minimum. That is why the law is very clear in that respect.
Yes.
Now, as far as the provisions of the Civil Code are concerned on inflation, extraordinary inflation, that is about payment. It's not about obligation or liability.
Yes.
And if it is about criminal sanctions, well, of course, I will not trust any law for my personal benefit if that law depends on a day-to-day statistic from the central bank.
Again, that's not what I'm proposing, Your Honor.
I'm just saying that. I know you are better than the central bank and better than the Congress. You have that great idea. And by the way, let me inform you and the rest that this case, this oral argument today is not at the behest of any of the parties. It's at the initiative of the court. We are really concerned about the excessiveness of this, but you see, the court is not so free as you think.
Well, I have never handled a case of this nature. The case on its face is pardon me for saying, a nothing case. It involves an ordinary embezzlement case. The amount is not mind-boggling. It's only 98,000. The plaintiff is the same with the accused. And yet, what has this honorable court done? It has appointed Amicus Curiae. It has requested the Solicitor General, the Senate, and the Legislature to give their comments. It has asked a special counsel to argue as the official, and has called for oral arguments en banc. Why? Because this honorable court knows that these penalties are absurd and unjust, and you want to do something about it. The only question is how. Now, I'm trying to open the door and give suggestions on how it can be done. And the best way I can see is by approaching the question through the doors of statutory construction, which I think is well within the authority of this court. Now, as to the nuts and bolts of how we will do this, we have encountered far more complex problems than this.
No,
And these problems can be resolved, because these problems will still face Congress. And in the meantime, thousands and thousands and thousands of poor Filipinos are languishing in jail.
No, okay. I was mesmerized by your first term today, this afternoon, harmonize.
Harmonize,
Yeah,
synchronize.
very attractive term. And it is inviting for us because we are not going to discuss the constitutionality
Yes.
or unconstitutionality of any legislative act.
You cannot imagine, Your Honor, how much time I've spent trying to divine the right word. My staff said regulate, modify, change, harmonize, synchronize. And I thought that the most acceptable word is harmonize.
I did not know you were a romantic. But anyway, you see, Justice Velasco has been so concerned about what do you suggest? Will you suggest? Please do that in your memorandum, because we really want to be of help, not only to Mr. Corpuz, who is not here, but to others similarly situated like him.
Yes.
This has been a concern even when we were in law school.
Yes.
But you see, I do not like to have a penal law that is dependent on the daily market forces.
It won't be. It will not be.
Okay, anyway, I'm done, Mr. Chief Justice.
Thank you.
Just one correction, no?
Yes, sir.
Because I was saying that earlier that the equivalent of 1 to 100, that 12,000 will now become 120,000. That's what I said a while ago. And that 22,000 will now become 220,000. I think I was wrong. Will you please show us the slide number 6? If we follow the ratio of 1 to 100, yung slide number 6, Article 315. Actually, I was wrong. The 12,000 will now become 1.2 million.
Times 100.
Yeah, the 22,000 will now become 2.2 million. Hindi maliwanag ah. Yeah. If the proposal is 1 to 100, if 1 to 100, the 12,000 to 20,000 will become 1,200,000 to 2.2 million pesos. Punishable by prison correctional maximum to prison mayor minimum. That means that the penalty is 4 years, 2 months, and 1 day to 8 years. Now, if the value now is, because the lowest penalty under the present law is 200, no? If the subject matter of the fraud is 200, the penalty is arresto mayor maximum 4 months and 1 day to 6 months. No? Now that 200 will now become 20,000 pesos. If we follow the 1:100 ratio. So what I'm saying is that, my point a while ago is this, no? If the subject matter of STAPA under 315 is 1.2 million to 2.2 million, then the penalty is 4 years, 2 months, and 1 day to 8 years. Do you agree, Attorney Bautista? Is that fair to the offended party? That if you swindled the victim in the amount of 2 million pesos, the accused will only get a penalty of 4 years, 2 months, and 1 day to 8 years, and the penalty will still be lowered by 1 degree because of the indeterminate sentence law? Will that be fair to the offended party?
You ask me?
Yeah.
Your Honor? Yes.
Yeah. Now, will that also be fair to the society?
To
To society.
society?
You can just imagine swindling a person in the amount of 2.1 or 2.2 million pesos will only carry a penalty of 4 years, 2 months, and 1 day to 2 years. And then you impose a minimum penalty. The minimum penalty will be taken from prison correctional minimum to prison correctional medium. So the minimum penalty that you can impose is 6 months and 1 day, 6 months and 1 day to 4 years, 2 months.
Your Honor.
So I can impose a penalty of 6 months and 1 day as the minimum penalty and a maximum penalty of 6 years and 1 day. When the amount swindled is 2.2 million pesos, is that fair to the private offended party?
Your Honor, these questions were answered by the Congress in 1930 using the values then. In those, if we just extrapolate the amounts.
But at that time, they did not anticipate that the value will be like this today.
No, we're talking of the value of the article, Your Honor.
No, my point is this, no? My point is this. In fact, that was the, it was brought out in the case of Solem versus Herm, the one that you cited.
Yes, Your Honor.
It said that the court can declare a penalty that's excessively harsh, no? Or not proportionate to the act, no?
Yes.
But it is suggesting that we have to consider several factors.
The 3 factors,
Yeah,
Your Honor.
they said, the decision said, the harm caused or threatened to the victim or to society and the culpability of the offender and the comparison of the severity of different crimes.
Yes.
So that is my point. If we just take into consideration the amount, which is 1:100 ratio, is that fair to society?
Yes. Those considerations, Your Honor, were taken into account by the legislators.
Will you allow yourself to be the victim of swindling in the amount of 2.2 million pesos, where the offender will only get a minimum penalty of 6 months and 1 day?
If that's the law, yes.
If one swindles you the amount of 19,000 pesos or 20,000 pesos, he will get a penalty of merely a penalty of 4 months and 1 day, or within the duration of 6 months.
If we extrapolate the values today to the values of 1930, that was the intent of Congress.
Will that be is that not harmful to society?
I don't think so. I don't think so, Your Honor.
Oh.
It is far more harmful to imprison impoverished, uneducated individuals.
So I will go back to my first statement that really we have to consider several factors
Definitely,
in determining the proper penalty to be imposed.
Yes.
It's not merely the value.
Yes.
Yeah, that was my point. That's why I'm showing to you this, because so that you will see
Yes.
that if the amount is between 1.2 million or to 2.2 million, we have also to consider the effect to society.
Yes.
Okay.
In fact, Your Honor, when I was first asked if I was open to considering appointment as the official counsel, my initial reaction was, hindi ba yan judicial legislation?
Talaga, judicial legislation.
That was my initial reaction.
I'm not saying, I was just commenting on what you were saying.
Yes. But when I took a much closer look at it, I think the construction of this honorable court, of that statute in 1930, will stand judicial scrutiny.
Yeah.
I think it will.
Yeah. My other point was, you already answered it, as to civil indemnity.
Yes.
The law itself under Article 2206 allows a higher amount of civil indemnity. Now, the other reason is that in the award of moral damages under Article 2220, and even, the law does not fix the amount of moral damages under Article 2220.
None.
That is discretionary upon the court, depending on the mental anguish or the sufferings of the private offended party.
Yes.
So the court can impose 100,000 moral damages, is it not?
Well, moral damages are different from actual damages.
Yeah,
as you know,
that's why. I'll go into that.
Yes.
So if the court can award moral damages in the amount of 100,000 pesos, then the court can impose more than 100,000 as civil indemnity, because the law says that moral damages should not be more than the civil indemnity, is
Yes.
it not?
As long as there's evidence to establish the factual basis for the moral damages, the court can do so.
Yeah. That's why in civil indemnity, the court
Has
is
the
allowed
discretion.
to increase
Yes.
the civil indemnity. Unlike in the penalty, we have to follow what is provided for by law.
And what is provided for by law, with due respect, is what the 1930 lawmakers passed.
Of course, it was enacted in 1932, but it's still the same law, so we have to apply unless amended.
Yes.
Okay, thank you, Attorney Bautista.
Counsel, I have a few questions. Okay, go ahead.
Concerning this problem that Justice De Castro raised about the possible difficulties in, can I have that microphone? This thing is... the problem that it may create in the lower courts or among lawyers is the fact that inflationary rate changes from day to day, for example. Yes. Like the stock of stocks and change, the value of stocks differ from day to day, and that may cause a problem. But you know, historically, as I've been saying, the court has fixed the amount that they thought was intended by legislature for a long, long time. For as I said, in 1949, the minimum civil indemnity for debt was fixed at 3,000 pesos. Today, if you fix it at 10,000 pesos, the court will say you are wrong, no? Because the minimum is now 75,000 pesos. So in a way, the court has interpreted the law, not rewritten it, interpreted the law in the light of inflation. All right. And then it changed that from 12,000 to 12,000 after 20 years. From 3,000 to 12,000 after 20 years. Well, because the Supreme Court noticed that there's been a big inflation in the meantime, double. So it doubled the amount from 3,000 to 6,000 to 12,000. No, well, more than double. And then in 1983, after 15 years, it raised the amount to 30,000 pesos. Did it cause confusion in the lower courts? No, it did not. The Supreme Court decision during those years of change were followed in the courts below. So for those period, the courts merely applied what the law said, 12,000 beginning from the time the court did it. And the court doesn't say, every day we will change the, that will be confusion and chaos and very impractical. The Supreme Court chose to periodically raise the civil indemnity after a number of years. 20 years, 15 years, from what I see here, 7 years, and the last time was 19 years. Because of the stability of the peso was not that great over a period of 19 years. So what I'm saying is that our lower courts and the Court of Appeals did not get into confusion. When they decide the case, they rely on the existing conversion rate or inflation rate adjustment established by the Supreme Court. So the Supreme Court provides a guide. So if this court says it is going to be 1 peso to 100 pesos, then from this time, the lower courts will adjust the penalties until the court makes another adjustment after 10 years probably, changing it again if there has been massive inflation. So the fear that there can be confusion is the same fear that we senior citizens had when the computer came. We did not want to touch it because of some fear, no? That it will disturb our lives or where we are. But now this one, no? This one, if we fix it at time, that will be uniform for all courts and it will be followed. Now, I think the other point raised is by Justice Bersamin. He said that in an estafa case, the prosecution will try to prove that the value of the property is 100,000 pesos, for example. And then therefore, the task now of the defense is to prove that it is not 100,000 pesos. I don't think that is what will happen. It is really 100,000 pesos on present value. So the prosecution, the defense will not dispute the value if there's evidence that is 100,000 pesos. It's in the implement, it's in the application of the penalties that will be a legal issue, not a factual issue, that the adjustment in penalty will be made. It will not be at the trial front. There's nothing, no, the trial is not going to change. I'm a trial lawyer for the last 40 years, and it will remain there. He will prove it is 30,000 pesos, and I will agree if it is really a check worth, money worth 30,000 pesos, no problem. Why will I insist on adjusting it to 1930? It's in the imposition of the penalty that the change is going to. Do you agree with that?
Absolutely.
Thank you, Chief Justice.
Counsel, I have a few questions.
Justice Carpio.
Let's go to the basics. The power to prescribe penalties for crimes belongs exclusively to Congress, correct?
Absolutely.
So the judiciary, the executive, doesn't have the power to prescribe penalties.
Does not.
Okay. Now, but the power of Congress to prescribe penalties is not absolute, correct?
It's not. It must be within the context of the constitutional parameters.
Okay, and those parameters...
Equal protection, cruel
and specifically for penalties, the Constitution says that there must be no cruel and unusual punishment.
Cruel,
correct?
inhuman, and degrading punishment.
Okay. Now, who determines whether the penalty is cruel and unusual?
The Supreme Court.
So, the Supreme Court.
Yes.
So, the power of Congress is to prescribe penalties. It's their sole power.
That's given.
Okay. But we can review that.
Definitely.
So, whether the penalty, the severity of the penalty, whether it should be 1 year, 2 years, 4 years, we can review that if it is disproportionate to the crime, correct?
Yes, it is well within your basic judicial
Okay.
function.
Do we have a case here in the Philippines where the court interpreted the cruel and unusual punishment clause?
Right now, excuse me. One of them, Your Honors, was U.S. versus Weems, which I cited before.
Yeah, okay. Let's go to that case.
Yes.
Basically, what did the court say, the U.S. Supreme Court say, that originated in the Philippines? What did the U.S. Supreme Court say in that case?
In that case, the accused Weems falsified certain receipts as having been paid to government employees. And he was charged and convicted. And the penalty was life, if I recall. And it had the cadena temporal, whereby he was made to wear a chain attached to his wrist and to his ankles. And then there were accessory penalties such as the deprivation of all rights to public office, all political rights, and he was not allowed to, I think he was deprived of the rights to visitation. The U.S. Supreme Court said that although the punishment in the 1600s, 1700s, and 1800s may be acceptable, in today's modern standards of human civility, they are no longer acceptable. And so the Supreme Court did not apply the penalty imposed by the lower court and reduced it.
The penalty imposed there was 15 years for
Yes,
falsification
with
of
cadena
public
temporal,
document.
I think.
Yeah. Well, that means 15 years is cadena temporal.
Yes.
And the court said that is excessive,
Yes.
disproportionate to the crime.
Yes.
So, would you agree with me that the phrase cruel and unusual punishment does not refer only to corporal punishment, but also to the duration of
Yes.
the imprisonment? So it's very clear.
It's very clear.
That is the rule in the U.S. and the rule here in the Philippines.
We can invoke U.S. versus Weems.
And when our people ratified the 1987 Constitution, they saw there the phrase cruel and unusual punishment is prohibited. They understood it in that sense, that you cannot impose excessive penalty disproportionate to the crime, correct?
In fact, if I may, using the nomenclature today, cruel, inhuman, and degrading is even a lower standard than cruel and unusual.
So would you say that in this case where the penalty will be about more than 2 years in relation to the amount appropriated is about 98,000,
Yes.
would you say it is now an unusual punishment
It's definitely cruel, excessive,
and unusual?
unusual, yes.
Well,
yes.
maybe not cruel, because cruel would refer to corporal punishment, but it
Well-
would be excessive and unusual.
Yes, but in terms of cruelty, Your Honor, in moral damages, for example, when you're proving sleepless nights, serious anxiety, mental anguish, the courts have ruled them as physical suffering. So if you incarcerate somebody in subhuman conditions for a long period of time, that is cruelty. Physical cruelty.
Okay, so, but the point is, the cruel and unjust punishment clause prohibits jail terms that are excessive
To the
or
offense.
disproportionate to the offense. That's
That's right.
settled.
That's right.
Okay. So if you want to question the jail term of the accused here, you can question its constitutionality under the cruel and unusual punishment clause, correct?
That's what I said. If the adjustment or modification is not done.
And it will be cleaner, because if we declare today that Article 309 and 315, with respect to the additional penalty of 1 year for every 10,000 pesos will be cruel and unusual, then that will be prospective.
Yes.
Applying to this case and in the future.
Yes.
But since the unconstitutionality is declared only today, all previous convictions will be constitutional, correct?
Yes.
So it's very clean.
Yes.
There's no complication.
Yes.
Okay. Now let us go to, you mentioned this earlier. A law may be constitutional when enacted, but over the passage of time, because of changed circumstances, the law can be unconstitutional, correct?
Relative constitutionality.
Yes, that's the debt moratorium law, and you mentioned that the BSP employees case.
Yes.
So 309 and 315 of the revised penal code, certainly they were constitutional even up to today, but because of changed circumstances, we can declare these sections, these articles in the revised penal code unconstitutional because they have become grossly excessive, correct?
Absolutely.
Okay, so there is no problem. It was constitutional in 1932, maybe in 1940, 50, and so on. But today, because of the change in circumstances, because of inflation, inflation being just a factor, the articles can be declared unconstitutional, correct?
Yes.
And if we declare the provision increasing the penalty by 1 year imprisonment for every 10,000, and
Incremental penalty rule.
yes, but the minimum penalty will remain,
20
then
years.
the crime of estafa is still punishable. There's still a penalty.
Yes.
It's only the additional penalty that will be declared unconstitutional, correct?
That's possible, the incremental penalty rule.
Okay. Now, your proposal is to index the penalty, the jail term, based on the adjusted value of the currency.
Yes.
So, in a criminal case, you have the penalty based on the amount appropriated if it's a theft or estafa, and you have the civil liability, which is the obligation of the accused to return the amount that was appropriated. So what you are saying is that both these values must be indexed to inflation? Is that what you're saying? The money to be returned will be indexed to inflation, so it will be returned times 100 now. If it was, if it's 98,000, what will be returned will be 980,000. Is that what you're saying?
Yes.
But is there not? But there is a provision in the Civil Code which says that the civil obligation to pay a debt cannot be indexed to inflation unless the central bank declares an extraordinary inflation. Correct?
Yes, yes.
So how will you now justify changing the civil liability, adjusting it to inflation, when the central bank has not declared any extraordinary inflation? You'll have a problem with your values.
Yes. I was only looking at the problem from the criminal
Side. Okay,
yes.
so there will be implications on the civil liability.
Yes.
Because there are two values that will be computed by the court. And would you agree with me that it will be simpler if what we'll declare unconstitutional will be the additional 1 year for every 10,000 and set the minimum, whatever is the minimum now, penalty, and Congress will wait for Congress to introduce a mandatory legislation to fix everything?
As I said earlier, I had two options in approaching this case. One is through the statutory construction door. The other one is through the unconstitutionality door.
Yes.
I felt that between the two, it will be more extreme and maybe more unpalatable for some of the conservative justices and probably to Congress if we will attack the constitutionality of the law. I thought that it will be more accommodating if we approach it through a statutory construction perspective. But clearly, the more simple, effective way to do it is to declare the law as unconstitutional, which I believe can be done.
Yes, because if you apply statutory construction, if you read the law, it's clearly the amounts are there. If you just apply the verbal legis rule,
yes,
that the 10,000 is 10,000.
Well, I was looking at the rule that the spirit and intent of the law should prevail over the literal words. And, Your Honor, I opted to take the statutory construction option because in StatCon, we try to avoid declaring laws as unconstitutional. But definitely, both options are available.
Okay, thank you, Counsel.
Thank you very much.
Yes, one more question from Justice Peralta.
Just one question because of the questions of Justice Carpio.
Justice Peralta.
Now, the proposal is that we can declare the incremental penalty as unconstitutional on the ground that it is excessive. That is one of your options, no?
I think the option suggested is to maintain the constitutionality of the incremental.
Yeah, but declare the incremental penalty as unconstitutional.
Yes.
Because it is excessive. Yeah. My problem is if the amount of fraud is 23,000 pesos and the ceiling of the penalty is 22,000 pesos, what penalty are we going to impose? That's another problem, no?
Yes.
I agree in some ways the proposal, but my problem will be if the fraud is 200,000 pesos, the amount of fraud is 200,000 pesos, and therefore it is more than 22,000, because the incremental penalty will only come into play
22.
if the amount of fraud is more than 22,000 pesos.
Yes.
So what will then the penalty that we are going to impose in the meantime that Congress is studying the possibility of amending if we declare the incremental penalty as unconstitutional?
We'll presume that
Shall
there
we
is no
impose the
incremental penalty.
Shall we impose the penalty provided for if the amount of fraud is between 12,000 and 22,000 pesos is not found in the law?
Yes.
That's my problem, no?
Yes.
Okay, thank you.
Mr. Castro.
I just want to go back to retroactivity.
Just-
Assuming that the court decides the case of Corpuz favorably, no?
Yes, Your Honor.
And that judgment becomes final today. And the basis was the declaration of unconstitutionality
Yes, Your
because
Honor.
of cruel or unusual punishment.
Equal
Now,
protection
and if
as well.
somebody was convicted, say, a few days before the finality of the decision in the Corpus case, or maybe weeks or months before, can that person convicted before the ruling of in the Corpuz case invoke the ruling and go back to court?
Well, may I suggest that the way out there is to invoke Article 5 of the Civil Code, and the court, perhaps the Supreme Court, en masse on a wholesale basis, or the individual trial courts, can write to the Chief Executive through the Department of Justice and ask for executive clemency and pardon. But I agree, if the court had jurisdiction to impose the penalty, it will be difficult to unwind that penalty by mere application of the judicial president. There has to be a pardon or a clemency by the executive, which is open by way of the Article 5 avenue.
So you don't think that there will be a problem about the constitutional guarantee of equal protection of the laws?
I don't think so, Your
Because
Honor.
you will be treating these two parties differently under the law.
Well, at the time they were convicted, that was the status of the law. The law had not yet been declared unconstitutional. So I think there may be leeway in saying that the equal protection doesn't strictly apply.
But executive clemency is discretionary on the part of the
Yes,
president.
yes. But I think if the Supreme Court asks the president will give serious consideration to it.
But there's nothing certain about
Nothing certain.
Yes, Justice Reyes.
Justice Reyes.
Yes, we will let them argue first, make a presentation. Thank you, counsel. You're excused.
Thank you, Justices.
We will now call from the respondents, Senior State Solicitor Hilbay.
Senior Associate Justice, Honorable Associate Justices, good afternoon and may it please the Court. I am here to discuss Parts A and B of the February 4 resolution of this Honorable Court requiring the Office of the Solicitor General to address the Court on the following matters. Whether or not the Court may modify by adjusting for inflation the penalty of 4 years and 2 months to 15 years the Court of Appeals imposed on Petitioner Lito Corpuz for the 98,000 fraud he committed, which penalty was computed based on the value of money in 1930 when the legislature enacted the revised penal code. And whether or not that portion of Article 315 that imposes a maximum penalty based on the amount of the fraud exceeding 22,000 should be declared unconstitutional and void for being disproportionate and excessively harsh in view of the decline of the value of money in 1930. The other parts of the resolution will be discussed by Assistant Solicitor General Pascual. Your Honors, so far as I can discern, considering that the petitioner never even raised any question about the justness or the constitutionality of the penalty imposed on him, the matter which this Honorable Court would like us to address concerns questions of legal philosophy and constitutional theory. In particular, the conceptual question of whether there's a relationship among criminal sanctions, time, and justice, and whether, as a matter of constitutional law, the question is susceptible of being resolved through the judicial process. In other words, are there judicially discoverable tools to answer these abstract questions of justice and penology? Are these judicial tools appropriate for the kind of analysis required to answer these questions? The answer to these questions, I humbly submit, is a negative. Your Honors, I apologize in advance for the non-doctrinal language of my discussion, though I hope the Honorable Court finds merit in the instrumental use of academic language, which in my opinion suits the kinds of questions posed by this Honorable Court in its February 4 resolution. Allow me to begin. The definition of crimes and imposition of corresponding penalties are matters of policy. They are value choices by the political departments, usually made from a host of competing options all of which are viable alternatives. To the extent that no single policy choice can be considered rationally or morally superior than the rest, these public actions are called exercises of naked preference, to borrow a popular term in constitutional theory. The area of criminal law is one subject of legislation where the capacity of Congress to exercise value choices from any given menu of options is generally recognized. For example, Congress is not constitutionally compelled to penalize swindling, theft, drug possession, drug use, or even drug abuse. It could very well consider such acts as unimportant to criminalize, or believe that imprisonment should not be the policy response to a particular social evil. Instead of sending people to jail, it can decide to simply create a civil remedy for the recovery of the sum of money swindled or stolen, with or without damages. And in the case of drug possession, just impose a fine, or for drug use, order mandatory rehabilitation. Whether to legislate the crime of swindling or impose only civil damages are alternative value choices for Congress. The same latitude of discretion applies with respect to the particular regime of penalties that Congress may impose for acts it wants criminalized. Going back to swindling, Congress could have chosen from a wide spectrum of valid policy options for determining a proper regime of penalties. It could have imposed any of the following penalty schemes with its own assumptions about the nature of culpability and the appropriate social response to it. Number 1 day of imprisonment for every 10 pesos swindled. This is variable imprisonment based on an absolute value, that is the peso amount of the fraud. It could have also chosen a regime of penalty under Article 315. This is also variable imprisonment based on absolute value as well, which is the peso amount of the fraud. It could have chosen a flat rate of imprisonment of 6 months, regardless of the amount swindled, with civil liability and damages. This is fixed imprisonment, and the amount of the fraud is irrelevant. It could have chosen no imprisonment at all, but only fine in increasing amounts depending on the amount embezzled. And so you have a regime of no imprisonment, but a variable monetary penalty. Or it could have chosen imprisonment, the term of which is based not on the value of the amount embezzled, but in proportion to the net worth of the properties of the victim. This is called imprisonment based on the relative value, the value to the victim. Another way to do it is by imposing a term which is based not on the value of the amount embezzled, but in proportion to the net worth of the properties of the perpetrator. And so this is another imprisonment form based on relative value, the value to the perpetrator. Finally, it could have chosen imprisonment, the term of which is based on the amount embezzled, valued in terms of the purchasing power of the peso to buy, say, 1 sack of rice in 1930, or 2014, or any other given year. This form of imprisonment is also based on a relative value, the purchasing power. I would like to highlight that this last option, imprisonment based on one particular species of relative value, the purchasing power, is what the Honorable Court seems to be proposing as a standard for penalty by adjusting for inflation the penalty in Article 315, or perhaps even the current scheme of penalties. All of these regimes of penalties I have mentioned, Your Honors, are constitutionally valid. This enumeration demonstrates the concept that given a plurality of legitimate alternative regimes of penalties available to Congress, there can be no singular standard of a just penalty. Following this premise, the idea of adjusting the penalties for inflation is purely a value choice of the type that Congress should make, not this Honorable Court. With all due respect, for the Honorable Court to make a value choice from a set of equally valid choices could amount to judicial legislation, and might encroach upon the prerogatives of Congress. I submit that this honorable court cannot exercise naked preference of this type without straining separation of powers. The fallacy in the attempt to adjust for inflation rests on the problematic assumption that the 1930s penalties in the Penal Code is the universal absolute standard of fairness of the penalties for swindling, or any other crime for that matter, such that the loss of purchasing power of the peso since 1930 somehow automatically makes the current provision remarkably unjust or disproportionate and therefore unconstitutional. With all due respect, the problem, Your Honors, is in the assumption that the value of the peso for purposes of imposing penalties should be determined by its ability to buy, over time, the same goods and services. In other words, the fallacy is the assumption that the standard of value should be a fixed purchasing power. This is clearly contrary to the penalty scheme under the Penal Code. What Congress legislated is this: the penalty for swindling and for both other crimes should be the absolute value of the peso, not its purchasing power or any other species of relative value. This regime of penalties based on absolute value reflects an implicit principle of proportionality that basically says, the more you embezzle, the greater the penalty. Both in 1930 and in 2014, this principle holds true. This principle of proportionality based on absolute value is generally fair and just, regardless of time, and the specific penalty scheme under Article 315 is simply an external manifestation of this principle of proportionality. What the Honorable Court appears to be attempting by adjusting for inflation is to legislate into the Penal Code a different scheme of valuation, which is only apparently fair, but ultimately arbitrary and not necessarily more fair. Whereas the current scheme of valuation is dependent on absolute value, what the court seems to prefer is the purchasing power of the peso. This choice of relative value is arbitrary because there is no rational justification for choosing one particular type of relative value over the others. What are these other types of relative value? I've already given two other possible types. Number one, the value of the property stolen in relation to the assets of the victim. And number two, the value of the property stolen in relation to the assets of the perpetrator. We can invent many other schemes of valuation which are just as value-laden as the next. What I am saying, Your Honors, is that the choice of the scheme of valuation for purposes of determining penalties is a complicated matter that involves the exercise of naked preference. It is a pure policy choice that representative organs of the government are institutionally capable of making and constitutionally empowered to do. It is a choice that this honorable court should not make in the guise of judicial review or statutory interpretation or even constitutionalism. Let me now go to another point, the matter of justice. This is a crucial consideration because the court, as a court of justice, may, at least in theory, decide to choose the morally and rationally superior policy option if that can be clearly demonstrated. Is the court's effort at adjusting for inflation more just and more rational? The answer is not necessarily. The foundational premise of this honorable court's resolution is that, as a matter of justice, a person who swindled 98,000 pesos in 2014 should suffer the same penalty as the person who embezzled 980 pesos in 1930, because 98,000 pesos in 2014 is equivalent to 980 pesos in 1930. With all due respect, this is a non sequitur. First, the Constitution does not require spatio-temporal symmetry in the application of penalties, anchored on the standard of purchasing power. There is no constitutional requirement that different people from different years or different decades suffer the same penalty on the basis solely of what can be bought with what they stole. The test of constitutionality or even the fundamental fairness of the penalty scheme is simply this. Is it so unfair to impose the current penalty scheme on people who live in the here and now, not then and now, or any time thereafter? Your Honors, the fairness of the penalty need not be tested over time. It need only be tested at any given time. With all due respect, the inclusion of a continuum of time in the analysis of the problem is unnecessarily complicating and perhaps irrelevant. We need not confront an intergenerational concept of pedology in order to resolve the present issues. In practical terms, whatever constitutional ambivalence or question of justice we are facing here can be reduced to this. Is it so morally repulsive and shocking to our collective sense of conscience that a person who steals 98,000 pesos be sentenced to a minimum penalty of 4 years, 2 months, to a maximum penalty of 15 years? The clear answer is no, because 98,000 is still a significant amount of money to the overwhelming majority of our population. We can unpack this question into a questionnaire. Number one, was it constitutional for Congress to impose a penalty scheme based on absolute value in 1930? Yes. Number two, is it constitutional for Congress to continue with the same penalty scheme based on absolute value? Yes. Number three, if Congress decided to penalize swindling for the first time today, would the current penalty scheme of Article 315 be so unfair as to be unconstitutional? The answer is no. This leads me to my next point. The fairness of the penalty can be made to depend on various forms of subjective or relative value. Even if the relative value of the peso has greatly depreciated in terms of purchasing power, its relative value to the victim or to the perpetrator is still highly indeterminate. These types of relative value have no correlation with inflation and can be used as alternative standards for determining the reasonableness of the penalty today, notwithstanding and even regardless of inflation. It is therefore highly problematic to peg the entire issue of the justness of the penalty on the purchasing power of the peso alone. In the same way that there is no necessary relationship between time and the intrinsic fairness of the penalty, there is also no necessary relationship between the purchasing power and the intrinsic fairness of the penalty. The Constitution does not require the government to maintain, over time, a relationship between the purchasing power of the peso and the penalty for a crime, as if there were some intergenerational justice that is implicated here. There's none. Allow me to illustrate. According to the resolution of the Honorable Court, the value of the peso is such that 98,000 pesos swindled by Corpuz now only has a value of 980 pesos by 1930's purchasing power standard. It is assumed that this is so unfair as to violate the Constitution because a person who stole 98,000 in 1930 effectively would have stolen 9.8 million pesos today, following the court's assumption. This analysis, while intuitively appealing, is not necessarily a slam dunk argument. For one, relative value is not the basis of the penalty scheme enacted by Congress. That scheme is absolute value. For another, it fails to capture the other forms of relative value of money, which are alternative measures of considering the justness of the penalty. It is therefore analytically under-inclusive. For example, a person named Anton Pandan is a government employee who earns 8,000 pesos net and has 3 children. Over the course of several years, and by sheer perseverance, he was able to save 50,000 pesos and borrow 48,000 pesos more from the local loan shark so that he can pay the down payment for a 50 square meter lot on which he can build his dream house. The realtor swindled him and left with all the 98,000 pesos Anton had saved and borrowed. Is it unconstitutional to impose a penalty of 4 years, 2 months to 15 years on the realtor? I think if we asked Anton, he would say that the penalty is much too low, and that people who swindle innocent, hardworking, and poor citizens like him deserve the death penalty. In this instance, it is clear that questions of justice in the severity of the penalty can totally bypass the notion that the penalty should be uniform over time and on the basis of purchasing power. This also demonstrates the falsity of the argument that the penalty scheme for property-related crimes should depend on purchasing power alone. The justness of a particular penalty or of an entire penalty scheme is a multi-layered problem that requires insights from social psychology, behavioral economics, sociology, political science, and many other disciplines. I submit that legal and constitutional doctrines are simply too limited and limiting for this type of an analysis. If at all, what the example involving our government employee means is that the depreciation of the currency since 1930 has had the resulting effect of simply adjusting the demographic impact of the penalty scheme, not its intrinsic fairness. Again, Your Honors, allow me to explain. Following the Court's analysis in its resolution, to maintain the relative value of the peso, we must adjust for inflation. Let me quote from the resolution. Since Corpuz may be deemed to have defrauded Tangkoy of the equivalent value of only 980 pesos, based on the value that the legislature contemplated in 1932, rather than the 98,000 pesos charged in the information, he should be meted out a penalty of only 4 months and 1 day as minimum, and 2 years and 4 months as maximum, a probationable penalty. The economics of penology implied here is that swindling in the amount of 98,000 pesos today should cost the perpetrator 4 months to 2 years of penalty. The unstated conclusion is that for Corpuz to deserve the penalty of 4 years to 15 years, he should have defrauded the plaintiff of 9.8 million pesos. Your Honors, the main characteristic of this attempt at an equivalence is only symmetry, not necessarily justice. The reason is that, as a descriptive matter, the consequential effect of adjusting for inflation is that the punitive high end of the penalty, 4 to 15 years, is effectively meant to protect people with 9.8 million pesos, a very small segment of the population. Whereas the punitive low end of the penalty, 4 months to 2 years, is directed at protecting those with 98,000 pesos, a segment of the population which is significantly higher. What I am saying, Your Honors, is that from a normative standpoint, maintaining the current penalty scheme which rests on absolute value is not necessarily unfair, as the inflation has only had the effect of shifting the demographic impact of the penalty towards the protection of the property of the poor and of the middle class. Because the poor and the middle class value 98,000 pesos more than those with 9.8 million pesos, the stiff penalty of swindling, 98,000 pesos, is actually more protective of the property rights of the poor and of the middle class. I humbly submit, Your Honors, that this is a relevant sociological insight about the relationship among time, justice, and penalty that should serve as a powerful reminder that the matter before us is not a simple one. It emphasizes the main thrust of the government's argument that subjecting the penalty scheme to constitutional analysis is an enterprise fraught with the dangers of oversimplification. While no one can doubt the power of constitutional law, it is still simply a discipline among the universe of disciplines that can be used to interrogate social issues. Let me end, Your Honors, with a summation of relevant points. Number 1, the test for determining the validity of the proposal in the resolution is this. Can it be established that the only standard for determining the intrinsic fairness of the penalty scheme in Article 315 is the purchasing power of the peso? No, it cannot. In fact, it is demonstrably not the case. Number 2, the standard of the penalty scheme in Article 315 is absolute value, not relative value expressed as purchasing power. This Honorable Court cannot change this scheme of valuation without violating the rule of verba legis. Number 3, the test of the validity of the penalty scheme in Article 315 is whether by today's standards it is so obviously repulsive and shocking to the collective moral conscience that those who embezzle 98,000 pesos are sentenced to a penalty of between 4 years and 2 months and 15 years. By this standard, Article 315 cannot be nullified. Finally, Given the court's concerns about the impact of inflation on the fairness of the penalty, the prudent and constitutional solution to this concern is the referral of the matter to the President pursuant to the procedure expressed by Congress in the Penal Code itself. This is found in Article 5 of the Penal Code. It states in part, duty of the court in connection with acts which should be repressed but which are not covered by the law, and in cases of excessive penalties. The court shall submit to the Chief Executive through the Department of Justice such statement as may be deemed proper without suspending the execution of the sentence when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. We submit that instead of exercising judicial review motu proprio or adjudicating ex nihilo, the court simply followed the procedure in Article 5, which allows the court to express its policy opinions and even preferences on the matter without the need to test for constitutional validity the current penalty scheme. This referral may offer crucial and relevant insights into penology, which I am confident the political departments will greatly appreciate, given that there are current efforts on the part of the Congress to amend the Penal Code. Thank you.
Thank you, Counsel. Yes, Justice Abad, yeah.
My impression from your presentation is justice consists of abstract principles used in defining crimes and impairing penalties. But we who enforce justice is to us the concrete case of a person appearing before the court asking that the law be applied to him justly and fairly. That's the difference. You know? Now, your position is that since the 1932 Penal Code says that 1 peso then in 1930 is still 1 peso today, we should live with this, since the legislature determined that it is absolute, fair, and just. That's correct? That's your position? The legislature adopted this absolute imprisonment based on absolute values, and we should consider it fair and just. That's correct? That's what you said.
What I'm saying, Your Honor, is that since the legislature chose absolute value, any questions about the justice of that penalty is over.
So do you disagree with my statement? Do you disagree with my statement?
Yes, Your Honor, I disagree.
You disagree that
Yes, sir.
Congress considers this fair and just?
That is assumed, Your Honor, in everything that they do.
Why do you say that Congress is wrong in treating this as fair and just? Because you say you disagree with
Your
me.
Honor, is that we cannot assume that Congress imposed injustice or, you know...
No, I'm just taking up from your propositions that the legislature chose this option where the penalty is absolute and that no room for adjustments, and that the court should accept it because
no, Your Honor, not
it is
that the
fair
penalty,
and just.
Not that the penalty is absolute, but that the value is absolute, and that
Yes,
absolute
the values is
value followed
absolute.
by the penalty.
I'm referring to that. You agree with me?
Yes,
in
Your
that
Honor.
sense, okay. Since you believe that, since we should believe that, would you send your kid to school every day with a small 1 centavo coin in his pocket for lunch and snacks because of your belief that the value of money since 1932 has not changed as determined by the legislature and is absolute and fair?
Your Honor, my belief is independent of my obligation to follow the law.
So you believe that? Well,
No, it's independent. It's irrelevant, Your Honor.
if you
I
do
simply follow
that,
the
if
law.
you give your child today 1 centavo baon for lunch and snacks in school, you would be condemning your kid to hunger and illness by that false belief, because that is false. That 1 peso in 1930 is also 1 peso today is absolutely false.
But, Your
Do
Honor,
you agree that they're the same? They're true? Is that true? I'm asking you. Is
False,
it true
Your Honor,
that the
false.
1 peso in 1930 is the same as the 1 peso in today?
depends on the way you value. If you say
No,
1 peso,
that's a simple question. Do you think that is true?
1 peso in 1930s, 1 peso today, that is true from one particular perspective. It's still 1 peso.
Well, I appreciate your position if that is your thing. That's why I said you will probably give your child.
That's entirely different matter, Your Honor. What I do to my child is different if I don't have a child.
So
Actually.
let me go to. Let me go to
I
another.
give
point.
more to my dog actually than to my child. So kung that, I mean,
Well, that's what I mean, no? It's false.
Yes, I know
Nobody
it's
can
false.
say that it is true, that the 1 peso in 1930 is the same as the 1 peso.
no, what
Anyway,
I'm saying, Your Honor, is that it's true.
Yes.
Because the Congress created a valuation system based on absolute value.
Yes,
That absolute value is still
Let me
true
go to
today.
another point.
Okay.
Your view is that the remedy in Corpuz case, in this case, is Article 5 of the Penal Code.
No, Your Honor. What my view is that
The
it is
his
an
remedy.
option for the court. I'm not saying that that is the remedy. The remedy is to
The
follow
remedy is
the
for
law.
the court, if it disagrees, for the court to resort to Article 5.
What I'm saying, Your Honor, is for the court to decide the case, which is an ordinary appeal so far as I can gather, and if it wants to, as an option, use the Article 5 procedure in
Yes,
the
so
penal code.
the option it can take is Article 5.
Yes.
Now, but in Article 5, the court, and I quote, will, taking into consideration the degree of malice and injury caused by the offense, in that court, the offense that was tried in that court, the penalty would appear excessive. And you know, this is best exemplified by a case that the Supreme Court decided a long time ago, where the court imposed the penalty for theft on a father and his son who stole 10 tender coconut fruits from a plantation solely for the consumption of the family. No, they're not, so they'll survive, so they'll have something to eat. So the court imposed the penalty provided by law, but appealed to the executive to consider that.
Yes.
Well, that is not the case here, no? The adjustment needed here does not take into account the degree of malice and injury that the accused in a particular case that has, you know. What we take into account is the fact that the penalty prescribed by law has become toxic through time. And it affects not just one accused in a particular case, but all those charged with crimes, the penalties for which depend on the value of money or the property involved. That's what is involved here.
What I'm saying, Your Honor, is that the assumption that the penalty has become toxic over time is a problematic assumption.
Oh, well, yes, I can take it because your position is 1 peso in 1930 is the same as 1 peso today. I understand
Yes, sir, because
that.
the penal code has not
I'm
yet
through,
been changed.
Chief Justice. Mr. Chief Justice.
Justice Leonen.
Good afternoon, Professor.
Good afternoon, Dean.
I am surprised by your position today. This is not vintage Professor Hilbay, the way I understand it. But let me be clear about your position. Your position is not to isolate this court from reality. Am I correct in saying that?
My position, Your Honor, is for the court to simply follow the text of the law.
But just pointing this out, it is not to result in the isolation of this court from having to decide on real facts that are brought before it. In fact, you would agree with me that what differentiates this court as a branch of government from Congress is that Congress deals with facts that are theoretical, brought before it, and this court has to deal with actual facts and actual cases. Is that correct?
Yes, I agree, Your Honor.
And you agree with me that in this particular case, there is an actual case, and that happens to be the conviction of one Corpuz, who is now out on bail. Is that not correct?
Correct, Your Honor.
Okay. Do you agree with me that this court does make value choices, and any court for that matter, even from the academic perspective, needs to make value choices?
Yes, Your Honor. All choices are in fact value choices, given
Okay.
certain assumptions.
So it is not your position that just because we make value choices, it's not your position that value choices are exclusive to Congress. Is that not correct?
I agree, Your Honor. And if I may,
And what you're saying, therefore, is that only naked, you use the word naked. And,
naked preference, Your Honor.
Naked, yes. I like that word, naked. Naked preferences is what distinguishes Congress from this court. Is that not correct? We do
Yes.
make preferences because we
Yes,
make value
Your Honor.
choices.
Yes.
And that our frame for value choices is text of the law. Is that not correct?
That's the first frame, Your Honor.
Yes. The first frame, of course, and the ultimate anchor that we should have, because we are a civil law country, is the text of the law. Is that not correct?
Correct, Your Honor.
Okay. Now, let's take a look at the law. It does say 22,000 pesos, correct?
Correct, Your Honor.
Yes. And pesos, of course, needs interpretation, what it is for. Is that not correct?
Not necessarily, Your Honor. Peso is the legal tender of the country.
Yes, legal tender, but the value incorporated or congealed in a peso is, of course, dependent on the context.
Not
Correct?
necessarily. Again, Your Honor, the value in Article 315
For example,
is
when we
extant.
say peso, we can refer to a medium of exchange. Is that
It's
not
possible,
correct?
it's possible.
Yes. When we say peso, we can refer to store of value. Is that not correct?
Possible, Your Honor.
Yes. So we have there a word in the text, peso, and it can refer to medium of exchange, and it can also refer to store of value. And it can also mean absolute peso in terms of the actual coins and the actual bills that we have.
If I may, Your Honor, I'd like to explain. These are not competing alternatives. What I'm saying, Your Honor, is that if you look at the text of the revised penal code,
Yes, it says
it indicates
22,000 pesos.
Yes.
It says 200 pesos or less.
Yes.
So
It
the
refers-
numbers seem absolute, but it is not simply a number, 200. It says pesos. Is that not correct?
Your Honor, what I'm saying is this is an absolute number. 200 pesos is 200
Yes,
pesos
if
in
you want to
2013.
focus on the number, then it's absolute. I would
Yes, sir.
agree with you. It's a whole number.
Yes, sir.
It is a real number. But if you want to focus on the entire law, it says 22,000 pesos.
Yes, sir. And
Yes.
by that, Your Honor, what I mean is 20,000 in a particular currency,
Yes.
and that currency is peso. And
Yes.
there's no doubt about it. And
There's
so-
no doubt about the
Okay.
fact that there is a concept called currency, but a currency has many uses. One is that it is a store of value, and I think that is what Justice Abad is pointing out. A medium of exchange, partly what Justice Abad is saying and partly what you are saying. And then also an absolute number, such as that number of coins, the reality of those coins is also what currency can mean. Is that not correct?
I would have to disagree, Your Honor. And if I may, I really would like to explain.
And if therefore pesos is a word that is contained in the text of the law, then it is the frame through which this court must make its own value choices. Is that not correct?
No value choice is required, Your Honor, because the text is already clear.
The text is clear. It says 22,000 pesos,
Yes, sir.
but it can be read in at least 3 ways that we have demonstrated.
No. What I'm saying is,
From your point of view, it can only be read one way because we understand that your advocacy. But then it may be clear to some of us that it can be read in 2 or 3 different ways.
if I may, Your Honor, I really would like to elaborate. I think interpretation or statutory construction has its uses, but it is of very limited use in this particular case because the standard of value is already there, absolute value. And the moment we deconstruct that value, then we're looking at an entire host of schemes of valuation which only Congress can choose. The moment we go into relative value, Your Honor, then we're moving into the area of naked preference.
But all value is relative. 22,000 to a person that earns 22,000 is everything. 22,000 to a person that earns 1 million is only 22,000 of 1 million.
And I agree, Your Honor,
Yes.
except that in the case of the
And
revised penal
therefore,
code,
when the revised penal code in 1930 said 22,000, it meant a specific thing or can be interpreted to mean one specific thing.
no,
Is that
Your
not
Honor,
right, Counsel?
no, Your Honor. In 1932, the Congress said 22,000 is less than 100.
Maybe I should put it this way, Counsel. What is our assurance that your absolutist view is the only way of reading the law?
I am not making an absolute claim, Your Honor. In fact,
Okay, let me rephrase it. What is our assurance that your view of what Congress intended is the only way to interpret that law?
I think, Your Honor, the question should be framed rather differently. What is the?
No, I am
mean, if
framing this question in this way
Yes.
because this is my vote.
Okay, okay.
And the question that
I-
I would
I
want to
know,
ask
yeah.
from you is what is our assurance that that is the only interpretation of the provision that you are proposing before us is the only viable interpretation in law?
If I were to stick to the statute and the text of the law, Your Honor, I would say that is the only way to read the statute right now.
Yes,
and
yes.
if you want to be
Again, what's our
faithful,
criterion for saying that your claim is true?
the text of the statute, Your Honor.
And also, we can rely on the text of the statute as we have relied with different points of view that we have so far proposed in terms of the first advocate, and still say that it is still within that particular concept. Is that not correct?
I'm sorry, Your Honor, but I really would have to,
Okay.
to disagree.
Let's go to another point, therefore, that it should be collectively shocking to the senses. You said that.
Yes, Your Honor.
Yes. And collective there means?
Well, I'd like to see some people on the streets, some advocacy groups, or
So we do
some...
a survey.
Congress will do the survey, Your Honor, not the court.
But will Congress really represent what is collective?
I'd like to think so, Your Honor.
Doesn't this court consist of 15 individuals? Yes.
Yes, that's
Yes.
Your Honor.
And we make decisions collectively. Is that not correct?
Yes, correct.
And there is a reason that we are a collegial court. Is that not correct?
Correct, Your Honor.
And when we say collectively shocking such that it appears to be unfair, as you have mentioned, then it is also possible for this court to make that judgment. Is that not correct?
I would have to disagree, Your Honor.
Cruel, inhuman, and degrading punishment. Those are words in the Constitution. You agree with me, Counsel?
I agree, Your Honor.
Yes. And who reads that? Congress?
Everyone, Your Honor.
Yes. And doesn't the court also, in its power of judicial review, need to make an interpretation of that provision?
In a very limited set of cases, Your Honor.
Yes, like Corpus versus People.
What I'm saying, Your Honor, not this case. Clearly not this case.
Yes. Next, you would say that there are many versions of justice. Is that not correct?
Correct, Your Honor.
Yes. And our duty in this court is to collectively decide in a particular case what that version of justice is. Is that not correct?
Only if it is properly called into performing that function.
Yes. When we perform our function, we don't just do it by logic. Otherwise, we will not be called justices, we will be called logics. Is that not correct?
Well, Your Honor, out of the three branches of government, only this institution is required to explain its decision.
Precisely. And therefore, in an actual case where there is already words found in a statute, where the litigant might say, or this court might interpret, that there must be certain exigent, extraordinary circumstances where we need to, again, read the meaning of that law, then that is precisely the function of the judiciary. Is that not correct?
What I'm saying, Your Honor, is that there is no case because the petitioner never even raised the matter beforehand. This is
there
adjudication.
Because the petitioner was imposed a particular penalty, and the proposal of the petitioner's counsel was that we do our role of interpretation, not really declare whether it is constitutional or unconstitutional.
Your Honor, I've read the documents. I don't think the petitioner ever raised the question of the constitutionality of the penalty scheme, or I don't remember
Courts
reading anything
need
about
to-
inflation, Your Honor, in the
Courts need
pleadings.
to implement a penalty, and in implementing the penalty, when reading it, and every act of reading, courts normally, or any person reading, uses a standpoint or a viewpoint. Is that not correct?
That is true, Your Honor,
Yes.
say theoretical
Because
matter.
we are not computers, correct?
No, Your Honor, but I
We
think
are human beings with our own life experiences, some litigators, some like you, academics, and some, of course, having had the same experience with the counsels who are bringing the case before us, need to interpret it from a particular point of view. Is that not correct?
I agree, Your Honor.
And for so long as that point of view wins the number of votes that is necessary, is in accordance with principle and within the text of the law, and that's a viable judicial interpretation. Don't you agree with me?
Not in this case, Your Honor. Not in this case.
In general, because you were talking in an academic language, and I'm now talking to you in that language.
Okay.
You agree with me?
Well, as a theoretical matter, yes.
Yes, but everything you said was also theory.
It has a lot of practical implications for this case, Your Honor.
So are we to decide on a lot of practical implications in this particular case?
I
okay?
agree, Your Honor.
There are two parts to conviction. One is finding liability, and second is sentencing the accused. Okay. Yes. And in this particular case, the crime is swindling. Is that not correct?
Correct, Your Honor.
And swindling consists of an act of defrauding an individual of something of value. Is that not correct?
Correct, Your Honor.
It is the penalty that we adjust in relation to that particular act, which is in question in this particular case. Is that not correct?
What I'm saying, Your Honor, is that it's not in question in this case because the petitioner never raised it.
But now, here in these oral arguments, that is the principal issue that we want you to tackle and address. Is that not correct?
In fact, Your Honor, I have addressed that issue.
Yes. So it is not simply the liability, but more importantly, the sentencing part, which is the value or the proportion of the penalty that will be imposed on the individual, which is in question. So
Correct.
liability is a bit objective because then you have to draw out the elements of the offense. But when you come to actually sentencing the individual, there is indeterminate penalties, for instance, and there is here now we are doing an interpretation of what should be the proper penalty given to the person that was convicted. Is that not correct?
With all due respect, Your Honor, what I'm saying is that sentencing is in fact more determinate than the determination of liability. Because the determination of liability requires finding of facts,
Yes,
whereas
but sentencing is more a
is
judicial
clear.
function, and the actual determination of what the element should be, as you said, is naked preference, as you mentioned. But in terms of looking at the person of the accused and the proportion of that penalty to the accused, that is entirely, principally a judicial function. Is that not correct?
I will disagree, Your Honor. Sentencing is highly constrained because it is it is the legislature that sets the penalties.
Okay.
And the courts cannot go beyond the penalties imposed by the legislature.
Maybe I go back to my first question. When the court interprets text in a law, should it not take into consideration what reality is? Because we are addressing concrete cases rather than theoretical ones.
I think, Your Honor, that is, again, as a theoretical matter, correct, but not in this particular case.
But theory and practice should be molded together. And that is precisely why we have a Supreme Court.
Yes, Your Honor, and what I'm saying is if we meld that together, then this court will have to perform its ordinary function, which is to read the law in the absence of any ambiguity.
Yes, but as we have said, reading the law is not as simple or simplistic as others would want it to be.
Not in this case, Your Honor, not in this case.
Yes, so it could not be simplistic. We have to read the law so that our better judgment of how justice is to be served is going to happen. Is that not correct?
Correct, Your Honor.
Thank you.
Correct.
Yes, Justice De Castro.
Now, you mentioned that the determination of penalty is a complicated matter involving the exercise of naked preference.
Well,
I want you to explain that further and do that in connection with the concept of proportional retribution mentioned by Attorney Mario Bautista. How do you explain these two concepts?
Yes, Your Honor. Thank you for the question, Your Honor. What I said, Your Honor, is that the determination of the justness of the penalty is a very complicated matter. And I think Justice Peralta referred to this a while back when he said that there's so many angles at looking at the justness of the penalty. In fact, it's so indeterminate that the best way to simply determine the justness of the penalty is by referring the matter to the Congress. Why? Because at the very least, if it's the members of the Congress who impose the penalty, then it's the true representatives of the people who said, well, for this particular amount, you go to jail for this particular length of time. And so we bypass the theoretical debate. You simply look at the statute. We leave the theoretical debate to, say, the academics or some other relevant group. That's what I'm trying to say. Your Honor, with respect to proportional retribution, right, I think the general rule of proportionality, which is implicit in Article 315 and most other penalties in the revised penal code, is the more you steal or the more you embezzle, the greater the penalty that will be imposed. It doesn't have to be absolute proportionality. It has to be only simply reasonable proportionality, given that you can only send people to jail for a certain length of time. Human beings only live for a certain length of time. And so you can't send them to jail for 5,000 years if they commit a 1 trillion peso fraud.
So if you agree that there is such proportional retribution, it means that Congress or the legislative body took into account the value of the peso in relation to crimes involving property. Otherwise, there will be no proportionality at all if you do not tie up these two matters, no? Yes. The value of the peso stolen and the penalty. That is the essence of proportionality.
I agree, Your Honor. I agree that it is really quite possible that the Congress took into consideration the existing purchase value of the peso in 1932. But the problem is the assumption, which I think is what is stated in the resolution as a theory. The theory of the resolution is that it should only be the purchase value that should be the basis of that scheme of valuation. And so I would agree with Justice Peralta when he says that, well, purchase value is a relevant consideration, but we cannot put all our eggs in that particular basket alone. The value to the victim, is that relevant? I'd say, of course. The value to society, I'd say, of course. And then, of course, the political considerations of Congress. Is this a leftist Congress? Is this a rightist Congress? Is this a centrist Congress? And so depending on the ideological assumptions of the collective, right, you would have a different scheme of valuation for every different type of a collective.
It may go into the factors that Congress should take into account in fixing the penalty, but it does not mean that the value of the peso is an absolute value. That insofar as Congress is concerned, will not change at all over time. Because that seems to be your position, that the value, that the penalty is tested as of the value of the peso at a given time. It does not change over time. That is your position.
Yes, Your Honor. And if I may explain just a little bit to avoid a confusion with respect to absolute value. When I say absolute value, what that means simply is that 100 pesos will always be bigger than 50 pesos. And 1,000 pesos will always be bigger than 500 pesos. That scheme was correct in 1930, 1932, or 1939. That scheme is still correct today. And that scheme is only an external manifestation of an implicit principle of proportionality. And if you want to test for constitutionality, it is that scheme of proportionality you might want to test. If Congress said if you steal 5 pesos, I'll send you to jail for 10 days. But if you steal 2 pesos, I'll send you to jail for 100 days. That would seem rather unfair and disproportionate.
So you do not think that the extraordinary circumstances obtaining today, which is 82 years after the revised penal code was approved and took effect, is not at all material to determine the justness of the penalty under the revised penal code?
What I will say, Your Honor, it is a material for determining the justness of the penalty as a legislative concern, not as a judicial concern. As a judicial matter, the obligation of this court is rather clear to me. There's an existing standard of valuation that seems to be rather still not shocking to our collective conscience, given the examples of Justice Peralta. What I'm saying, Your Honor, is that if we want to test for justness, then we go to the proper forum. That proper forum is the Congress, because they are the representatives of the people. If Congress said we want to adjust for inflation, then who are we to complain? If Congress says we don't want to adjust for inflation, we want the poor and the middle class to be protected of their 98,000 pesos, who are we to complain? You might want to change our representatives, but that is the democratic way, Your Honor.
Okay, let's pursue that argument further. You mentioned that the law is protective of the property of the poor victim. What about the perpetrator? Is it also protective of his constitutional right that will require the court to step in and protect that constitutional right?
What I'm saying simply, Your Honor, is that if we're looking at the justness of the penalty today, an important and relevant consideration would be, but not an exclusive consideration, the property rights of the victim. Am I concerned with the property rights or the constitutional rights against cruel and unusual punishment of the perpetrator? Of course. But that question is best left, again, Your Honor, to the Congress, because that clause is only used in extreme cases. We don't want to use it every time we believe Congress has been lagging behind with respect to its legislative work. In fact, we cannot even assume that the Congress is simply lagging behind. What we should assume is that, given today's penalty scheme and penal code, that Congress still considers this penal code as just and fair.
I will agree with you that the valuation of the penalty is a complicated matter and that many factors will come into consideration, in the same way that the court will have to take into account a lot of considerations and factors for us to be able to arrive at a ruling demanded by or proposed by the Council for Corpuz today. Okay, thank you. That's all.
Yes.
If I understood your absolutist theory correctly, because the discussion has gone a little bit deeper, the 200 peso value, for example, or as stated in the law, did Congress at the time just pluck that out of thin air? Because the absolutist value, as I understand from you, is 200 is different from 22,000, different
Yes.
from 1 peso.
Yes, sir.
And you don't consider the valuation or the equivalence in value of these amounts, such that you said you read the law as written and apply the law as written. And just a question, my question is, what would be or what could have been the consideration of Congress in choosing 222,000 and 1 peso? Yes. Or was that just a just plucked out of thin air?
Yes.
Just a number?
Yes. Thank you, Justice Perez. I would have to assume, Your Honor, that when the Congress in 1930 chose a particular number, 200, 12,000, 22,000, they chose from a host of considerations.
That's it.
Not just purchasing power. Not just purchasing power. They chose from a host of considerations. What those considerations may be, I don't know, because we don't really have access to the records.
That's right.
But again, Your Honor, what I'm saying is, the assumption of the resolution seems to be that we have to adjust simply because of the devaluation of the peso. What I'm saying, Your Honor, is that that is rather problematic because you are pegging your scheme of valuation on a particular type of relative value, just one particular type of relative value, that is the purchasing power of the peso. What I'm saying, Your Honor, if you want a full consideration of the justice of a particular penalty today, then use your Article 5 power and refer the matter to the Congress, as in fact, the Congress is already taking a serious look into the problem. I believe that the project has gained some traction already because the President himself spoke about it.
Which means to say that your absolutist theory is not really the sole answer to the solution of this problem, or does not solve this the problem before the court. And
Yes,
I will guess that your answer to the question of Justice Leonen is no. The absolutist theory is not the sole basis for a decision of this court. And I also guess that you...
If I may clarify, Your Honor, by absolute, what I'm saying, if as judges, as people who are not members of Congress, right, if you look at the revised penal code, there's only one scheme of valuation, and that is absolute theory. And the moment we bring into the consideration relative value, such as purchasing power, then we might as well go into relative value to the victim or relative value to the perpetrator.
And you're
or
saying that is already intruding into the legislative domain.
That is clearly, Your Honor, the realm of legislation.
Thank you. Thank you.
Okay, Counsel, I have just one question. Supposing Congress passes a law imposing for the crime of theft 5 years imprisonment for every 10 pesos stolen. 5 years imprisonment for every 10 pesos stolen. Here is a man, a jobless man, who steals a loaf of bread worth 40 pesos, and so he's convicted to 20 years imprisonment. Can this court declare that law unconstitutional for being cruel, inhuman, or degrading?
Well, Your Honor, in theory, the court, it might be possible for the court to do that. But let me just hasten to add that we cannot use as an example for an ordinary case such as swindling of 98,000, an extreme case such as that, because in the first place, I don't think that kind of law will pass in Congress. And so we cannot use an extreme case to try to nullify an ordinary case.
I'm not relating it yet to this case.
Sorry,
what I'm just trying to ask you is, what is the extent of the power of this court under the Constitution to declare criminal law prescribing penalties cruel, unjust, cruel, inhuman, and degrading?
What I would say, Your Honor, is that the extent of the power of the court is a matter of a self-consideration of what the members of the court can do given a particular context.
So this court has the power to declare such a law unconstitutional?
I'm not saying, Your Honor, that the court has the power to declare the law unconstitutional. What I'm saying, it should be addressed to the good sense of the members of the court.
If the members of this court think that the law is degrading, cruel, or inhuman, then we declare it unconstitutional, correct?
Not necessarily, Your Honor.
So
what I would say, Your Honor, is that not only should the court as a collective think it to be fair, cruel, inhuman, and degrading, but that belief should also be, clearly justifiable from a rational standpoint.
We believe it. We sincerely believe it's cruel, inhuman, and degrading. Do we have the power to declare the law unconstitutional?
What I'm saying, Your Honor, is that not just the members of the court, because everything that the court does is basically a matter of
So who else should make that decision?
In terms of formal decision, Your Honor, it's the court.
It's the court.
Really no doubt about it.
So we have that power, yes or no?
In terms of naked power, yes, of course.
Under the Constitution, do we have that power?
If it's just a power, yes, of course.
Of course.
Yes.
Okay, thank you, Counsel. There are no other questions.
Thank you, Mr. Justice Corpuz.
Yes, we ask ASG Pascual to argue now.
Associate Justices of the Supreme Court, good afternoon, and may it please the Honorable Court. This representation will discuss the following issues. C, whether or not procedurally the Court may determine the constitutionality of the penalty that the Court of Appeals imposed on Corpuz, even when he did not raise such question in his petition for review, and in the affirmative, under what circumstances can such determination be done? And letter D, whether or not the penalty that the Court of Appeals imposed on Corpuz violate the Equal Protection Clause, EPC, or the Unusual Punishment Clause, UPC, of the Constitution, and if so, what standards need be met before a penal law or parts of it can be declared unconstitutional on either of these two grounds. Number one, we urge this Honorable Court, with our highest respects, to please exercise judicial restraint. The requirements of judicial review are meant to preserve the separation of powers of our government. The Court's power of judicial review is subject to the following limitations. One, an actual case or controversy calling for the exercise of judicial power. Two, the person challenging the act must have standing to challenge. 3, the question of constitutionality must be raised at the earliest opportunity. And 4, the issue of constitutionality must be the very least mota of the case. With due respect, Your Honors, if this Court proceeds to determine the constitutionality of the penalty under Article 315 of the Revised Penal Code, even if such issue was never raised by the petitioner, then the requirements of judicial review are violated. Corpuz should have raised the constitutional issue during trial. This Honorable Court should not raise the issue on its own and rule on it. Moreover, this Honorable Court has repeatedly said that courts should refrain from touching the issue of constitutionality unless it is truly unavoidable and is the very lis mota or crux of the controversy. Lis mota literally means, quote, the cause of the suit or action, unquote. These last requisites of judicial review is an offshoot of the presumption of validity accorded the executive and legislative acts of co-equal branches of government. It is rooted in the principle of separation of powers. Given the presumed validity of another branch's act, the petitioner who claims otherwise has the burden of showing first that the case cannot be resolved unless the constitutional question he raised is determined by this court. In Soto versus the Commission on Elections, this honorable court has ruled that a court should not pass upon a constitutional question and decide a law to be unconstitutional or invalid, quote, unless such question is raised by the parties, unquote. Your honors continue that the contention in the dissenting opinion that, unquote, whether the point of unconstitutionality of the provision of Act Number 657 is raised or not by either party, we cannot close our eyes to the constitutional mandate, is therefore evidently erroneous. Number two, as to the Equal Protection Clause and the Cruel and Unusual Punishment Clause, it is submitted that stare decisis forestalls any perceived violation of the Constitution. In People versus Judicial, Justice J.B.L. Reyes said, to constitute cruel and unusual punishment, penalty should be, and I quote, inhuman and barbarous or shocking to the conscience, I quote. And fines or imprisonment are definitely not in this category. In People versus Estuista, this honorable court ruled that to come under the ban, the punishment must be, quote, flagrantly and plainly oppressive, wholly disproportionate to the nature of the offense, as to shock the moral sense of the community, unquote. Moreover, in Lim versus People, this honorable court ruled that the existing penalty under Article 315 of the Revised Penal Code is not cruel and unusual punishment. The fact that PD 818 did not increase the amounts corresponding to the new penalties only proves that the amount is immaterial and inconsequential. To date, it is our submission that Lim versus People remains the proper standard. In Agbanlog versus People, this honorable court ruled that assuming arguendo that inflation has in effect made more severe the penalty for malversation 21,000, the remedy cannot come from this court but from Congress. The court can intervene and strike down a penalty as cruel, degrading, or inhuman only when it has become so flagrantly oppressive and so wholly disproportionate to the nature of the offense to shock the moral senses. Considering that malversation of public funds by a public officer is a betrayal of public trust, this court did not say that the penalty imposed on petitioner is so disproportionate to the crime committed as to shock the moral sense. Lim and Agbanlog were both decided under the 1987 Constitution. In closing, allow us to refer to the House of Representatives, whose comment dated October 20, 2013 stated that the President already directed the recodification of laws, one of which is the Revised Penal Code. As a result, the Department of Justice formed the Criminal Code Committee through Department Circular Number 19 dated 20 April 2011. This recodification of our Revised Penal Code by Congress, with the help and recommendations from various sectors of the government and our society, is a significant step towards updating archaic terms, deleting superseded and redundant regulations, and settling once and for all conflicting issues brought about by antiquated provisions. As it bears on the present controversy, no longer will the court be plagued and accused with application of outdated laws and harsh penalties, unquote. Thank you, Your Honors.
Just one question. I just want to verify from you. What happened to the proposed bill? You were talking about proposal to amend the revised penal code.
Good afternoon,
In
Justice
Congress,
Peralta. Yes.
there is now a proposal coming from the Department of Justice. Did you say that?
Your Honor, what happened was, as early as 2010, President Pinoy Aquino has ordered a revision of our codal laws. And one of these offshoots is a recommendation by the Department of Justice for the recodification of the RPC.
So it's now pending. It's now pending in the lower house.
Yes, Your Honor, as headed by Congressman Neil Tupas, there was a hearing conducted already last August 2013.
Oh, there's already a public hearing.
Yes, Your Honor.
But I heard from the others that what's now in Congress is the proposed revision on Book 1.
But there's also an ongoing provision on revisions on Book 2. As a matter of fact, yes, Your Honor, we had been in touch with the Department of Justice, and we were actually given a draft copy of some portions of Book 2.
You have already seen the proposed?
There is an
amendment
ongoing...
to Book 2, on Book 2?
Yes, Your Honor.
Did you see there a proposal to amend crimes on property?
Yes, Your Honor.
Is that already included in the proposal?
I was told, Your Honor, yes.
You haven't read that proposal?
No, when I was discussing the matter with the Department of Justice, with all modesty, Your Honor, they said that Professor Tadjar, one of the amici, is part of that committee, Your Honor.
Yeah, because I read the comment of Professor Tadjar that the remedy here is legislation. Thank you.
Thank you, Justice Perez.
Just one question, Counsel. In the recent PDAF case, the Greco-Bellica case, the petitioners did not raise the constitutional issue of whether lump sum appropriations negate the President's constitutional power to veto line items. It was the court that required the parties to address this issue. You remember that?
I am not privy to that case, Your Honor.
Okay. And in Sharif Kabunsuan, the constitutionality of the creation of the legislative district was not raised by the parties. It was this court that required the parties to address that issue, and we ruled on the constitutionality of the legislative district created by the armed legislature. So it's not correct to say, Counsel, that the parties themselves must raise constitutional issues. We can require the parties to raise constitutional issues if we believe that we cannot decide the case without addressing the constitutional issues. Correct, Counsel?
With all due respect, Senior Associate Justice, if I may be allowed to refer to my notes.
Yes.
We were just reading the text of Section 5, Article 8 of the Constitution, which states, the Supreme Court shall have the following powers. Paragraph 2, revise, reverse, modify or affirm on appeals or certiorari as the law or the rules of court may provide final judgment and orders of the lower courts in A, all cases in which the constitutionality or validity of any law is in question.
Yes, we, the court, can put that in question because we may not be able to decide the case unless the constitutional issue is addressed. So we require the parties to argue, address it in the oral argument and in their memorandum. So it's addressed by the parties, it's raised. Correct?
If it is addressed by the parties, Your Honor, if it is raised by one of the parties.
Yes, that's why we are raising it now. In our advisory to you, we ask you to argue on the constitutional issues.
Again, Your Honor, with highest respects, If I may be allowed to refer to Francisco versus the House of Representatives, this honorable court has ruled that the question of constitutionality must be raised at the earliest possible opportunity.
Yes, the
That is
earliest
why-
possible opportunity for this case is now, because we realize that we don't want to decide this case without addressing the constitutional issues, because the accused here, we believe, will suffer cruel and unjust punishment. That's why we want to address this issue. And we have required you to argue on this and to address this in your memorandum. So it is raised properly. You understand, Counsel?
Based on my notes, Your Honor, I'm
Yes,
having
your
some
notes. But you read
difficulty.
Sharif Kabunsuan
Yes.
and the PDAF case, okay, and several other cases. Thank
Yes,
you,
sir.
Counsel.
Thank you, sir.
We invite our Amicus Curiae to make their presentation now. Congress is here? Yes, Attorney Valentina Corpuz, representing the Senate or the Congress?
Representing the Senate, Your Honor.
Okay, thank you. Senate.
Your Honors, the Senate President could not be present at today's oral arguments since he presided at the session of the Senate this afternoon. So I was tasked to present his side of the issues. The Senate President, in his capacity as the friend of the court, would like to articulate his views on the issues and questions which the Honorable Court is seeking to resolve in the present case. On the issue on whether or not the penalty under Article 315 of the Revised Penal Code should be modified by considering the present value of the thing subject of the offense, adjusted to 1930 prices, the Senate President believes that the law should merely be applied as it is, inasmuch as the law is clear, categorical, and unambiguous. He believes that there is no need for judicial interpretation or construction in this particular case. Even if the law is perceived to be harsh, there is no choice but to apply the same, and the only recourse is to amend the law by the enactment of appropriate legislation by Congress. His view is anchored on the principle of separation of powers enshrined in our Constitution. If the court were to modify the penalty by considering the present value of the thing, adjusted based on inflation, he believes that the Honorable Court may be accused of engaging in judicial legislation. Moreover, even assuming arguendo that the resulting penalty under Article 315 of the Revised Penal Code, if applied in accordance with its provisions, could be considered disproportionately or excessively harsh, still he respectfully submits that the remedy is not an adjustment of the penalty due to inflation, but a resort to the second paragraph of Article 5 of the Revised Penal Code. This allows the Honorable Court to submit to the President, through the Department of Justice, a recommendation for executive clemency. On the issue on whether or not that portion of Article 315 of the Revised Penal Code should be considered unconstitutional and void for being disproportionate or excessively harsh, the Senate President believes that it should not. Section 19, Paragraph 1 of the Bill of Rights of our Constitution prohibits only excessive fines, and he maintains that similar allegations of unconstitutionality of excessive sentences of imprisonment have been presented before the court in the past, but such penalties were consistently upheld as being constitutional. In the case of Agbanlog versus People of the Philippines, for instance, the petitioner questioned the penalty imposed upon him, 11 years and 1 day of prisión mayor as minimum to 16 years, 5 months, and 11 days of reclusion temporal as maximum. He contended that given the value of the peso in 1930, when the Revised Penal Code was enacted, the penalty for malversation of 21,000 pesos should only be 1 to 2 years. The court considered the penalty imposed upon petitioner as not being flagrantly oppressive or so wholly disproportionate to the nature of the offense so as to shock the moral senses. In this particular case, the Honorable Court even went on to say that even assuming that inflation had made the penalty for malversation of 21,000 pesos more severe, still the remedy could not come from the court but from Congress. In the case of Jovencio Lim versus People of the Philippines, petitioners questioned the constitutionality of Presidential Decree 818, which amended Article 315 of the Revised Penal Code by increasing the penalties for estafa for being violative of the constitutional provision against cruel, degrading, or inhuman punishment. It must be recalled that the petitioners in this case were sentenced to reclusion perpetua, or 30 years imprisonment for their bouncing check in the amount of 365,000 pesos. This honorable court ruled that the penalty imposed by Article 315, as amended by PD 818, was not unconstitutional, nor was it disproportionate to the nature of the offense, nor was it excessively harsh. Finally, the honorable court has in numerous cases upheld penalties which were perceived to be unduly harsh or excessive. Examples of these are the penalties of life imprisonment for the sale of 5 pesos worth of marijuana, 6 months imprisonment, and a fine of 2,000 pesos for profiteering, and reclusion temporal maximum to reclusion perpetua for simple illegal possession of firearms. On the issue of whether or not the mode and duration of the penalty under Article 315 of the Revised Penal Code violates the cruel, degrading, and inhuman punishment clause of the Constitution, suffice it to state that the Honorable Court has consistently held that the prohibition against cruel, degrading, and inhuman punishment is generally aimed at the form or character of the punishment rather than its severity. Penalties such as whipping, burning at the stake, breaking on the wheel, disemboweling, and similar punishments are considered cruel and unusual and thus unconstitutional. On the other hand, fines or imprisonment are not considered cruel, inhuman, barbarous, or shocking to the conscience, even if they are perceived to be severe in terms of amount or duration. On the issue of whether or not the mode and duration of the penalty under Article 315 violates the Equal Protection Clause of the Constitution, the Senate President believes that the penalty does not violate the Equal Protection of the Laws Clause because it provides for a reasonable classification of the penalty to be imposed, that based on the amount of the fraud committed. The increases in the penalty to be imposed as the amount of fraud increases is germane to the purpose of the law, which is to place higher burdens of liability for persons who defraud others in increasingly higher amounts. The classification of penalty is also not limited to existing conditions because it applies equally to those who committed the crime soon after 1930 when the law was passed, at the present time, and even for future commissions of the crime. It should also be mentioned that if the penalty to be imposed under Article 315 of the Revised Penal Code were to be adjusted based on 1930 prices, might not this modification of penalty apply as well to other crimes under the Revised Penal Code, whose penalty also depends upon the amount involved, such as malversation of public funds or property under Article 217, robbery under Articles 299 and 302, theft under Article 309, and malicious mischief under Article 328 and 329 of the Revised Penal Code. Finally, for the Honorable Court's information, the Senate President would like to manifest that there are at present 56 bills now pending in the Senate seeking to amend the Revised Penal Code. These were filed in the present period, the first regular session of the 16th Congress, although there is no bill seeking to amend Article 315 of the Revised Penal Code on estafa in particular.
Thank you, Counsel. You're excused.
Thank you.
May we request Dean Jokno to make his presentation now?
Good evening, Your Honors. Before I begin, may I just express my thanks and appreciation at this opportunity to share my views with the Court. It's not often that counsel gets to have this kind of exchange with the members of the Honorable Court. May it please the Honorable Court, counsel has three issues that he would like to focus on this evening. These issues have already been discussed a bit by the other counsels, but perhaps not in the angle or perspective that I would like to present to the Honorable Court. If I could get the slide correct. The first issue, if Your Honors please, is can this Court go beyond the literal meaning of the incremental penalty rule for estafa and theft as provided in the revised penal code? Second issue, does the incremental penalty rule violate the Equal Protection Clause of the Constitution? And third, does the incremental penalty rule violate the constitutional prohibition against cruel, degrading, or inhuman punishment? But before I go into the legal issues, Your Honors, I believe it's important that we first understand really what is this legal animal that we call the incremental penalty rule. Particularly, how do I view this particular rule, or how do I define it? I am referring in particular, Your Honors, to the rule contained in Articles 315 and Articles 309 that provides 1 year of additional imprisonment for every 10,000 pesos over the amount of 22,000 pesos stolen or swindled. What this rule means is that a person could have an additional imprisonment of between 1 to 12 years depending on the amount involved, from 32,000 to 142,000. And of course, that would be on top of the basic penalty provided, which for amount of 12 to 22,000 would be 4 years, 2 months, and 1 day to 6 years as minimum, or 6 years and 1 day to 8 years as maximum. There's another feature, Your Honors, to the incremental penalty rule. It also provides for a ceiling or a cap, that any amounts stolen or swindled over 142,000, even if they reach the billions, will receive the same penalty, a maximum penalty of 20 years imprisonment. In this particular case, Lito Corpuz was convicted of taking or swindling 98,000 pesos, and he was given a maximum penalty of 15 years imprisonment by the Court of Appeals. But perhaps we should take an even closer look at this rule. In the first place, if Your Honors please, it is unique. It is a special rule that is applicable only for estafa and theft. We do not find this in crimes that are other than crimes against property. It is, of course, of colonial vintage. It began or was incorporated in the Penal Code of Spain of 1870 and then was retained in our revised penal code. It has never, to counsel's knowledge, been amended, this particular IPR or incremental penalty rule. It has never also, to counsel's knowledge, been assailed as absurd or unconstitutional. That is until now. How about in other countries? I believe it is important that we put this in context not only domestically but internationally. We got this from Spain, but the IPR, the incremental penalty rule, is no longer used in Spain. It is not used in the United States under their federal laws. It is not in use in France, Canada, Australia, Germany, Japan, Bolivia, and other countries. It is used in the United Kingdom, or there is a version that is used there, but the amounts are much higher because it is a new law, and it is in keeping with the legal, economic, and social realities of today. What are the present penalties for estafa? In other countries, sometimes it's called swindling, embezzlement, or fraud. In Spain, it is a maximum of 8 years. In Canada, 10 years. Australia and the United States, and I believe Germany also has a penalty, maximum penalty of 10 years. Earlier I mentioned the United Kingdom. There is a range of penalties or an incremental penalty rule in the UK, but the amounts, if Your Honors please, are consistent with today's realities. For less than 17,500 pounds or less than in Philippine pesos, 1,295,637 pesos, the penalty is only up to 21 months. For amounts between 17,500 to 100,000 pounds, that is between 1.2 to 7.4 million pesos, the penalty is only 2 to 3 years. From 100,000 to 250,000 pounds, the penalty is 3 to 4 years. From 250,000 to 1 million, it is 5 to 9 years. And there is a cap which is set at 1 million or more, and that is 10 years plus as above. In other words, if we were to compare the penalties in the United Kingdom and in the Philippines for the same amount or for an amount less than 17,500 pounds, in the UK that would merit a sentence of 21 months or 1 year and 9 months. In our jurisdiction, that would merit a penalty of 20 years. Of course, the world was very different in 1930 when the code was enacted and when it took effect in 1932. The peso exchange rate with the dollar was only 2 pesos to 1. So 10,000 pesos at that time was equivalent to 5,000 US dollars. At the present rate of exchange, the same amount of 10,000 pesos would only be equivalent to 224.42 US dollars. Another thing is that in the 1930s, when the revised penal code was enacted, human rights was not yet a part of the world's vocabulary. Child labor was allowed, women could not vote, discrimination was rampant, the concept of social justice was not yet firmly entrenched in many countries. Acts that we now consider human rights violations were acceptable to many societies at the time. And in the Philippines and many other countries, the penalties for crimes against property were at par with, or sometimes even higher than, crimes against persons. In fact, in the 1930s, the international human rights instruments that we are very familiar with today were not in existence. There was no Universal Declaration of Human Rights, no international covenants on civil, political, economic, social, and cultural rights, no Geneva Convention, no conventions on the rights of women, children, and other vulnerable sectors, and no conventions against torture or enforced disappearances. In other words, Your Honors, please, the concept of human rights had not taken hold in the world. But today the world is very different. Human rights are not only recognized, they are protected not only by international law, but by very specific domestic laws. Social justice is now a part of our Constitution and part of the agenda of our government. And our courts, particularly this court, has recognized the primacy of the rights of persons over property rights. I quote very briefly from the Philippine Blooming Mills case. While the Bill of Rights also protects property rights, the primacy of human rights over property rights is recognized. Because these freedoms are delicate and vulnerable, as well as supremely precious in our society, and the threat of sanctions may deter their exercise almost as potently as the actual application of sanctions, they need breathing space to survive, permitting government regulation only with narrow specificity. And our economy is also very different. As I mentioned earlier, today, the equivalent of 10,000 pesos in dollars would only be $224, whereas in the 1930s, the equivalent of 10,000 pesos was 5,000 US dollars. I believe that the incremental penalty rule was reasonable when it was enacted 80 years ago. That is, when 10,000 pesos was equivalent to US $5,000. But I raised the questions. Is 10,000 pesos still worth a year of imprisonment when it is only equivalent to $224? Is it reasonable to peg a year of imprisonment at 10,000 pesos in this day and age? I submit, Your Honors, that the incremental penalty rule is unfair, unjust, and absurd. It is unsuitable for modern society, unreasonable and unacceptable by present standards, and ridiculous to apply today. Why is it unsuitable for modern society? In the first place, Your Honors, it is not in harmony with today's legal, economic, and social realities. It gives rise to unduly harsh, unnecessary, and prolonged sentences for property offenders. And it is disproportional. Crimes against property in the millions and billions should deserve the highest penalties. Crimes involving thousands to hundreds of thousands of pesos and less should be given lower penalties. And yet, because of the cap of 142,000 pesos, there is no difference in penalty between one who commits estafa in the billions and one who commits estafa only in the hundreds of thousands. Is it reasonable, I pose the question, that a person convicted of estafa or theft of over 142,000 will receive the same maximum penalty as one who commits homicide? He will receive the same maximum penalty as one who commits direct assault, as one who commits arbitrary detention, and one who engages as a participant in a rebellion. I think the chart graphically shows that there is no distinction made by the law between these different crimes, when I believe that there are very clear distinctions between them. Is it reasonable that a person who commits estafa in the amount of 32,000 pesos or higher will receive a higher maximum penalty between 9 to 20 years than one who commits frustrated homicide, which would be 8 years and 1 day under the case of Adame versus Court of Appeals? I believe it is well settled that the right to life and injuries to life deserve the highest protections by this court, and yet the sentence, as you will see, is lower for frustrated homicide than for someone who steals or swindles 32,000 pesos, well, between 32 to 142,000 pesos. Is it reasonable that one who commits estafa involving billions will receive the same maximum penalty as one who commits estafa involving over 142,000 pesos? When the revised penal code and the incremental penalty rule were enacted in 1930, I cannot conceive that the framers of that law could put millions, because at that time it was inconceivable for those amounts to be the subject of theft or swindling. And that is probably why the amount that was pegged by the framers of the code was only at 142,000. But nowadays, I believe it is not uncommon anymore to hear of cases and encounter cases involving millions, if not billions, of pesos swindled or stolen. Is it reasonable that a person convicted of estafa or theft of over 142,000 will receive a maximum penalty of 20 years when the same offense in other countries would merit, in the UK, up to 21 months, in Spain up to 8 years, and in other countries like the US, Australia, Canada, and Germany, up to 10 years. I believe that as far as property crimes are concerned, we have among the highest penalties in the world, and I believe that is because of the incremental penalty rule. Is 10,000 pesos a reasonable equivalent to a year's imprisonment? 80 years ago, I believe it was. But I don't think it is now still a reasonable amount for a year of imprisonment. What is the law on this score? I think the law is very clear, if Your Honors please. Courts are not bound by absurdity. Quoting from the case of Ursua versus Court of Appeals, where the literal application of a law leads to absurdity, injustice, unfairness or defeats the clear purpose of the lawmakers, courts may find its meaning in its spirit and in reason. But can the court go beyond the four corners of a law? Well, in the case of Commissioner of Internal Revenue versus SM Prime Holdings, this Honorable Court said, when the application of the law would lead to absurdity or injustice, courts may take judicial notice of the origin and history of the law, citing U.S. versus De Guzman, the deliberations during the enactment, citing People versus De Gamo, as well as prior laws on the same subject matter, citing Celestial Nickel versus Macro Asia. So there is jurisprudence to back up the proposition that this court can go beyond the literal wording or four corners of the incremental penalty rule. I believe that the incremental penalty rule is not only absurd, it defeats the very purposes of criminal law, which include reform and rehabilitation of offenders whenever possible. This is found not only in our domestic law, but also in the International Covenant on Civil and Political Rights. I quote, "The penitentiary system shall comprise treatment of prisoners, the essential aim of which shall be their reformation and social rehabilitation." Also from our own indeterminate sentence law, the purpose of that law is to uplift and redeem valuable human material and prevent unnecessary and excessive deprivation of personal liberty and economic usefulness. Comparing crimes and comparing criminals, Your Honors, I believe that someone who is convicted of a crime against property could very well be reformed and rehabilitated, probably much easier than someone who is convicted of a crime against person like murder or homicide. And yet, what is an impediment to their reformation and rehabilitation is precisely the incremental penalty rule. Thus, if we follow established jurisprudence, I submit that this court may take judicial notice of the following. 1, the origin and history of the revised penal code, the prior laws on the same subject. 2, the fact that other countries like Spain, United States, Australia, France, Canada, Germany, Japan, and Bolivia, among others, do not use the incremental penalty rule in crimes against property. 3rd, the gross disparity between the penalties for estafa and theft in the Philippines and those provided in the UK and other countries, among others. I submit, Your Honors, that to avoid absurdity, this court may retain the incremental penalty rule, but if it will do so, it should increase the incremental amount from 10,000 to perhaps 100,000 pesos per year of imprisonment, or by some other means consistent with today's legal, economic, and social realities. I submit that this is not judicial legislation, but the essence of judicial duty. Quote from the 2 articles of the Civil Code, "No judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws." Article 10, "In case of doubt in the interpretation of laws, it is presumed that the lawmaking body intended right and justice to prevail." If You're honest, if I have time, I would like to proceed with very briefly on the issues of equal protection and cruel and unusual punishment.
Kindly wind up, Dean.
Thank you. Just one point, if You're honest, please, about the Equal Protection Clause. I believe that the Equal Protection Clause is violated in this case because the incremental penalty rule singles out the crimes of estafa and theft and gives them a harsher penalty than they deserve. It gives them a penalty that is equivalent to the penalties for homicide, arbitrary detention, rebellion, and some other crimes that are even much more serious than crimes against property. And I submit that there is neither a rational basis nor a compelling reason for that kind of classification. As far as the cruel and unusual punishment clause is concerned, Your Honors, I would just like to point out the case of Solem versus Helms, comparisons that are contained in those 3 factors. In closing, if Your Honors please. I believe it is high time that this honorable court take a closer look at the incremental penalty rule. The rule is an anachronism that has no place in modern society. If the incremental penalty rule will be retained, the amount should be increased to correspond to today's legal, economic, and social realities. Otherwise, it should be struck down for infringing on the Equal Protection Clause and violating the prohibition against cruel, degrading, and inhuman punishment. Thank you, Your Honors.
Thank you, Dean Doctor. May we ask Professor Tadyar, are you still presenting? Okay. Yes, please, please approach the podium, or would you like to discuss your sitting down?
Good evening, ladies and gentlemen of the Supreme Court. Like my predecessor, I'd like to start out by saying thank you for inviting me to give my opinion on the matters that have been formulated. And what I'd like to do is that to point out that had I not received a Master of Laws degree from Harvard University, or having taught in the University of the Philippines for 20 years, I am certain that I would not have been invited to address this august body. And the relevance of this observation is that in 1969, when I applied for a leave of absence, I was then municipal judge of a provincial capital town of San Fernando, La Union. And under the subservience of the judiciary at that time, because we achieved administrative supervision over lower courts only in 1973, we were required to file a leave of absence and in the Secretary of Justice. And I was appalled that the then Secretary of Justice doused all ambitions in me when he said, "You have no need of a graduate studies. You are a lowly first-level courts. What will you use for a graduate degree?" So, had I not persisted, I would have been stuck in San Fernando, La Union. And the reason why I mentioned that is because the next Secretary of Justice was Vicente Abad Santos, who took a more liberal view because he was my former dean at the UP College of Law. And he readily granted me a year's leave of absence to study in Harvard University. And I wanted to show that because today, as has been mentioned in several of those who made the presentation, that statutory provision that shows the subservience of the judiciary is still being invoked. And that refers to Article 5 of the revised Penal Code, wherein the Supreme Court, the remedy that was suggested here by all of the speakers is that is the proper remedy, that in case of excessive penalty, taking into consideration the degree of malice and injury. Refer the matter to the President of the Philippines through the Secretary of Justice under Article 5 of the Revised Penal Code. To me, that shows the subservience of the judiciary, and to invoke it is a retrogression of the progress that we have made since 1973. Now, I would like to start my presentation with a relevant quotation, and that is, "The methods by which we enforce our criminal laws have aptly been called the true measure by which the quality of our civilization may rightly be judged." That is a quotation of Chief Justice Warren Burger of the United States Supreme Court. And I'd like to bring into consideration the relevance of that quotation, because the last 3 days, PMA Cadet Aldrin Jeff Kudia was imposed the maximum penalty of dismissal from the academy just before his graduation this coming March of 2014. He would have been salutatorian of his class. The ground for dismissal was lying about the reason for his being 2 minutes tardy for the next class. And it is reported that the PMA Honor Code is absolute and does not distinguish between the degree of the offense committed once they lied, cheated, stole, and this significant portion is, or tolerated the commission of these offenses. There is only one punishment: dismissal. The rule clearly makes no attempt to make the imposition of the penalty be proportionate to the gravity of the offense committed. That, I believe, is the principal issue that we are here to discuss. Had the penalty been imposed on Kudia by a court of justice, I am certain that it may be struck down for unconstitutional vagueness. Because what is the meaning of tolerating the commission of those offenses? And rectification of an injustice, there seems to be no appeal in the PMA. Would not suspension in the case of Kudia teach the lesson that is intended to be taught? So, now I'd like to focus on the fourth formulation of issue letter C, whether or not procedurally the court may determine the constitutionality of the penalty that the Court of Appeals imposed on Corpuz, even when he did not raise such question in his petition for review, and in the affirmative, under what circumstances can such determination be done? I'd like to 194 in June 11 of 1901, passed by the Second Philippine Commission. From 1901 to 1987, when the 1987 Constitution became effective, what was the basis for exercising the power of judicial review? And a brief survey would show that we had been exercising the power of judicial review under the American doctrine fashioned by John Marshall, in the case of and this is something interesting, because it is Justice of the Peace William Marbury versus the Secretary of State. So here was a lowly Justice of the Peace who sought by mandamus to compel by the Secretary of Justice, the Secretary of State in the United States, to compel him to issue his commission, even after he was appointed by President Adams. And there, the question then of judicial review, exercising the power of judicial review under the American doctrine of Marbury versus Madison. That is the extent of the power that we had. There was no express power of judicial review that was granted to this court. And in 1910, it looks like our Supreme Court of the Philippines exercised the power of judicial review in the case of U.S. versus Wims. And in the case of U.S. Wims, who was sentenced to hard and painful labor for 15 years. Fortunately, it was appealed to the Supreme Court of the United States, and it was struck down as being cruel and unusual under the American Constitution. So the point is, may judicial power be exercised to strike down said penalty as unconstitutional in the case of Lito Corpuz without being raised by Corpuz? And I say, the answer that I propose is yes, since Corpuz has suffered an injury from a literal application of a penal law based on the value of the Philippine peso set in 1930, more than 83 years ago. What then are what I consider to be the essential elements of bringing the matter to the petition for the review of the Supreme Court? Number one, an injury must have been caused by the statute. And when I say injury was caused by the statute, it is not necessarily a personal injury to the accused himself. It could be an injury to the separation of powers that I cited earlier. So, the second is that the statute must have been cited by a party to the case. And indeed, the statute was cited in an opposition by to the motion for reconsideration filed by Corpuz. And so that became involved. And so I say the other condition, therefore, is that the issue is inextricably linked to the core issue, which is the disproportionateness of the penalty based on the devalued currency value. Now, let me go to what I feel, therefore, should be struck down is Article 5 of the revised penal code as showing the subservience of the judiciary to the chief executive. The second that I'd like to talk about would be the value of the Philippine peso. If you will note, we have been talking about the value of the peso. It was always been purchasing power of the peso. And yet, Justice Leonen was mentioning that the peso could be talked about in terms of the medium of exchange. So therefore, as told by Dean Jokno, in 1930, the peso was pegged at 2 pesos to $1. So therefore, $1 could purchase 2 pesos. So the 200 pesos, as I take a look at it, is that now that it is 2013, it is now 43 pesos, and the 200 peso value would be 4,300 pesos. And the 22,000 maximum would be 73,000 pesos. So, for those years. It should also take into consideration the per capita income at that time. Please note that in the case of the complainant in this case, he had purchased those jewelry in Thailand, in baht. The baht was only worth $2, 2 bahts and 3 bahts respectively. should we not also therefore take into consideration the foreign currency that was involved in the purchase of this? So there we can see therefore that as it is mentioned, the National Statistics Office only mentioned about the purchasing power in 1957. What happened between 1930 to 1957? So I had talked about the question, therefore, that is posed for our consideration this afternoon is whether, letter A, whether or not the court may modify by adjusting for inflation the penalty of 4 years. And my position is that is not within the power of this court. The power of judicial review is merely to declare unconstitutional or constitutional in the exercise of this power of judicial review. So what I'd like to propose is that the incremental penalty of 15 years should be struck down immediately as unconstitutional, because my argument here is that the incremental penalty is 7 years on top of the 8 years of the principal penalty of prisium maior as maximum. I compute, therefore, that the additional penalty of 7 years that the Court of Appeals had imposed would amount to 87.5% of the principal penalty. It's almost double the principal penalty imposed. I'm not so sure whether the notice given is that the sentence was pronounced by the Regional Trial Court of San Fernando City, Pampanga. But in the case of the OSG, it was supposed to have been imposed by the Regional Trial Court of Olongapo. So I don't know which one is correct or not. So I'm looking at the significant dates here, and 1803 was the date of decision of Marbury versus Madison, which established the power of judicial review. I therefore traced that from June 11, 1901, when the Second Philippine Commission decided to establish the Philippine Supreme Court, the case was under the petition for review of Marbury versus Madison, not any constitutional issue. So Wims versus Case was therefore where the Philippine Supreme Court must have exercised the power of judicial review, and it was overturned by the United States Supreme Court. December 8, 1930 is the approval of the revised penal code. May 2, 1991 was the date complainant Danilo Tangkoy entrusted to the accused Lito Corpuz the jewelry bought in Thailand in bahts. So should we not also consider the currency valuation of bahts? On July 30, 2004, the RTC of San Fernando City passed sentence on Corpuz. So if you'll take a look at 2004 up to the present time, 10 years have already elapsed. So I'm saying that the lengthy time that it has taken this court to pass on this matter may also be equally as lengthy as the one in Congress. Thank you.
Hello. Just one question, Prof, my favorite professor in the Philippine Judicial Academy.
Yeah.
We have been going around the Philippines giving lectures.
Okay.
Yeah. Just one question. You are suggesting that in order to determine the value of peso, you have to take into consideration several factors.
Yes.
Yeah, per capita income.
Per capita income.
Consumer price index,
Yes.
inflation, and
Yes.
so on. Is the Supreme Court equipped to determine those factors?
There are many ways by which the value of the Philippine peso can be determined, utilizing all of those economic terms.
Yeah, but
And I don't think it is within the power of the Supreme Court to pass upon and peg the value to 100 pesos to 1 peso.
That
in
is
1930.
legislative in nature.
That is my position, that the Supreme Court has no power to utilize the power of judicial review in order to adjust, to make the adjustment. That is a power that belongs to the legislature.
Thank you, Professor.
Justice De Castro.
Thank you.
I just have one comment.
Yes,
Remember, Judge Stadjar, we used to work together in the Katarungan Pambarangay.
Yes.
And I have a very high respect for you. Knowing you during the
I
many
hope
years.
that that's not in the past tense, because
No, it still
she
holds.
had a very high respect for me, which was lost by my presentation.
No, it still holds up to now. Remember that the penalty in the revised penal code really presented a big problem for the jurisdiction of the Katarungan Pambarangay Lupon.
Yes.
As originally passed, the jurisdiction of the Lupon will cover only theft involving properties worth 5 pesos. So
And
when
up
the
to
law...
imprisonment of up to
that was later on. So you worked for the amendment of the Katarungan Pambarangay law, and as amended by the local government code, the penalty now cognizable in cases cognizable by the Lupong Tagapayapa would be 1,000 pesos fine and 1 year imprisonment.
Yes.
And with that change,
5,000 pesos.
no.
5,000 pesos
5,000.
fine.
With that amendment, only theft involving properties worth 50 pesos will be covered by the Lupong Tagapamayapa Authority. So
There are many other considerations, because under Article 39 of the revised penal code, subsidiary imprisonment is going to be placed at 2 pesos and 50 centavos per day of imprisonment. I'd like to inform this honorable body that in the Criminal Code Committee, of which I was a member, the subsidiary imprisonment has already been abolished, because it is principally directed against the poor, which constitutes 27.5% of our entire population. So there's no one of the wealthy or the middle class or the upper class who will not be able to afford to pay the fine. So it is directed only against the poor, and therefore that Article 39 should go. So there is no more subsidiary imprisonment filed under the new criminal code.
My point is just that the penalty provided for in the revised penal code really pose a problem.
Yes.
Not only as in this case of Corpuz, but also in the grant of jurisdiction to the Lupon for amicable settlement.
Yeah.
So only very few cases involving theft.
In fact, let me just mention that the subsidiary, the compromise agreement of first-level crimes under the new criminal code. By the way, I'd like to inform that this is not a revision of the penal code. It is a provision to create a new code. It is not a revision of the penal code, because we took into consideration all of the acts that were passed from 1901 to the present time, including the special. They were all considered, so it is not a revision of the penal code. We went out to produce an entirely new code.
Thank you, Judge.
Justice Reyes.
Justice Reyes.
Question to Dean Nanjokno, please.
question is for Dean Jokno.
No,
Thank you, Professor Tadyar.
thank you.
You may take your seat now.
Good evening, Your Honor.
Good evening, Dean Jokno. I just want to be clarified on certain few points. Based on the disquisitions, either orally or in writing, I do understand that as far as Dean Candelaria, Dean Jokno, and Professor Tadyar all agree that Article 31, Paragraph 1, should be struck down for being violative of either the Equal Protection Clause or the prohibition against cruel and unusual punishment.
Yes, Your Honor, Article 315.
So am I correct?
But in my particular argument, I focus on the incremental penalty rule only, Your Honors.
And based on the present answer made by Professor Tadyar, she thinks that the legislature, that it is the legislature and not this court who can make the necessary adjustments.
Well, ordinarily, Your Honor, I would agree that in an ideal world, then it should be the legislature that should be prescribing this. But we are in a situation where the legislature has not addressed a problem for more than 80 years. And it is in a case where the court is called upon to exercise its judicial function of deciding a concrete case before it. In this kind of situation, I submit, Your Honor, that the court will have no choice but to exercise its duty to decide the case.
To even impose adjustments on the provisions.
Well, there would be two options, as I see it, that would be available to the court. If the court will go through the statutory interpretation route, then following the jurisprudence that where the law is absurd, the court is not bound by the four corners of the law, then the court may apply extrinsic factors to interpret the law. On the other hand, if the Honorable Court will declare the incremental penalty rule unconstitutional, then that portion of Article 315 and 309 perhaps will no longer be in existence.
All right, Mr. Dean, if the court would assert its authority to take cognizance of the constitutional issue in this case, what should be the limit of such exercise? Should it end after having declared Article 315, Paragraph 1 as unconstitutional, or should the court proceed to fill the gaps? And as you have stated, it would depend.
I believe if the incremental penalty provision of Article 315 is struck down, then the remaining sentences of those who are convicted will still remain, Your Honor. Now, of course, the other issue that the court would have to tackle if they make a declaration of unconstitutionality would be what will be the effect of this on those whose cases have already been decided, but whose convicts are still serving sentence, because surely they will probably file some actions
so I'm referring to this case of
yes, Your Honor.
The accused Corpuz. If the court would proceed, if the court would proceed no further than exercising its authority to declare Article 315, Paragraph 1 as unconstitutional, what are the practical implications to Corpuz and others who were convicted of the same offense?
If the entire, I don't think the intention, Your Honor, is to declare the entire Article 315, Paragraph 1 unconstitutional. If all the penalties there are declared unconstitutional, then Corpuz and the others would probably have to be released.
Yes.
If it's only the incremental penalty of 1 year for every 10,000, Your Honor, then only the additional penalty would be vacated.
So it is very clear that you are just addressing the issue on the incremental.
That is my argument, Your Honor.
All right, thank you very much.
Thank you.
Hello. Okay.
Now, your position is that the incremental penalty should be struck down as unconstitutional because it is absurd.
Absurd, it violates equal protection, Your Honor, and cruel and unusual punishment.
Then what will be the penalty that we are going to impose if the amount of the fraud is more than 22,000 pesos?
Well, that would be for Congress to, if this court will declare the incremental penalty rule unconstitutional, then the void should be filled by Congress.
But in your presentation, you were fixing the amount at 100,000 pesos.
Well, my
for every 100,000 pesos in excess of 22,000 pesos, you were suggesting an additional penalty of 1 year. Did I get you right?
Yes, Your Honor. That is if the court will take the route of statutory interpretation. If the court will say that they can go beyond the literal wording of the law,
but if we declare the incremental penalty as unconstitutional, the court cannot fix the amount.
No, Your Honor.
As the equivalent of as an incremental penalty in excess of 22,000.
No, Your Honor.
The court cannot do that. The only remedy is to go to Congress and determine the value or the amount that will be equivalent to the incremental penalty of 1 year in excess of 22,000 pesos. The amount in excess of 22,000 pesos. Thank you, Dean.
Thank you.
Justice Leonen.
Good evening, Dean.
Good evening, Justice.
You were mentioning a while ago that this kind of law and the consequences that it has now is quite extraordinary. For example, daily our courts attend to crimes against property. Is that not correct?
Yes, Justice.
All our courts, from MTCs to the Supreme Court, deal with crimes against property. Is that
A substantial number of the crimes before our courts involve crimes against property. Your
And
Honor.
these are under contemporary circumstances. Is that
Yes,
not
Your
correct?
Honor.
Yet we are governed by a pre-colonial law. In fact, a colonial law, which is dated in 1930 and only made effective in 1932. Is that not
Yes,
correct?
Your Honor.
And therefore, this is the extraordinary circumstance and will not apply to other laws which may have the value of the property as basis for the penalty. Is this not correct?
Yes, I agree.
Okay. In your experience, when subversion was repealed by Congress, what happened to those that were incarcerated?
They were released because there was no more crime to speak of, Your Honor.
And the remedy that was availed of by some of the flag lawyers in order to gain the release of people that were incarcerated by subversion was a petition for habeas corpus as a post-conviction remedy. Is that not correct?
Yes, because under jurisprudence, that would be the only legal remedy to question their sentences after final judgment.
Now, Dean, in that instance, when there was this subversion, I think Presidential Decree number 33, other laws that were passed during martial law that were repealed under the government of President Cory Aquino, was there a deluge of petitions that were filed with the courts, the lower courts, or was it sufficient that there was a single precedent or a couple of precedents in order to advise the courts that there was no such crime already?
If I recall, Your Honor, there were some cases filed, but I would not describe it as a deluge.
Yes, and therefore, if we corrected the penalty or read the penalty in the right way, then probably there will be a few cases that will be filed with this court just to clarify the interpretation of this court in terms of jurisprudence. But it will not certainly be a deluge of cases that will bog down the entire judiciary.
Would
I be
agree.
correct in assuming that?
Yes, I would agree.
Yes. You were pointing out to the value of 10,000 in relation to other countries in your presentation. Is that not correct?
Yes, Your Honor.
That's with respect to the incremental penalty.
Yes.
Does that not apply also to the basic penalty in swindling?
It would apply to the basic penalties, but there are many complications if even the basic penalties are to be disturbed, Your Honors.
Okay. What is involved here may be the power of judicial review if we declared portion of the law as unconstitutional. Is that correct?
Yes, Your Honor.
Or the other power might simply be the power of the court simply to interpret the law. Is that not correct?
Yes.
Yes. Thank you.
Justice Velasco.
Counsel, I'm a little persuaded to subscribe to your position that the application of 315 is can be considered as unjust or even absurd. But what I'm grappling with is who will fix the present-day value of the amounts contained in Article 315, and how will it be done? Because definitely I cannot compute the present-day value, and you just mentioned legal, social, economic factors, and if you remember the Valentine scale of values, no? And that was used in the determination or the resolution of the disputes involving the currency during the Japanese War, right? And I believe the Valentine scale of values was arrived at after a study of several factors. And Dr. D.L. Valentine is a special bank advisor to the President. And the Valentine scale of values was used by the courts in several cases. As a matter of fact, judicial notice was taken of the Valentine scale of values. Now, if we agree to your position, how will the court proceed from here? Do we engage the services of an expert to determine what really now is the present-day value of the amounts prescribed in Article 315, and also probably in theft, in the provision on theft or even malversation? How do we proceed with that? What will be the formula that the court will use in case we subscribe to your position?
If the court will declare the incremental penalty portion as unconstitutional, then that will no longer be a function of the court. That will be left to Congress to come up with the amending legislation.
We skirt that issue. We say, as Attorney Bautista said, we don't have to deal with the constitutional issue. We just interpret the law. And because there is an ambiguity created by the changes in the value of the amounts prescribed in Article 315, we'll just have to interpret it. And so there's no need to resolve that constitutional issue. And so we just determine what is now the present day value of the amounts prescribed under Article 315, and how do we do that? What will be the formula? And do we engage a commissioner to determine that, or refer it to or create a panel of experts to determine what really now is the present value of these amounts?
Well, I believe, Your Honor, that the court can do this in the same way that it does other issues which are not within its normal understanding. As mentioned by Your Honor, the court could hire commissioners, it could request consultants from the economic sector to submit their input, subject, of course, to the approval by the members of the court and by the court as a whole.
There being no, thank you, Dean.
Thank you.
You're excused. We wish to thank our Amicus Curiae for their enlightening presentation. We greatly appreciate your presence here today. I'm sure we will take into account what you have discussed here. The parties are given the option to submit their respective memoranda within 15 days from today. It is just an option because we understand you have already submitted extensive memoranda on the issues here in this case. So it's just an option for the parties to submit their memoranda 15 days from today. There being no other matter, this oral argument is adjourned.
Please rise. Please remain standing.